Carl
jury is
Steinbeck here.
absent from the courtroom.
Want to
waiting
cover
for
this
us
case
outside
on white,
before,
the murder case.
and
Let's jump
Marty
right
wanted to
into
do
it.
some things on the record.
Yes, Your Honor.
This is cross-examination
I
that's
would
going to happen
like to
today.
revisit a couple of the motions in limine issues that I believe need to be revisited after the defendant's testimony yesterday. The defendant testified yesterday specifically about an incident where he was aware that Deanna, I don't know his last name, but Ariel's best friend called him, quote, a monster. And defendant testified that he believed Ariel was minimizing the affair and that he was essentially spreading giving Deanna wrong information about the affair. What Ariel was actually talking to Deanna about was that the defendant was using sexual coercion against her. The defendant was demanding that Ariel have sex with him whenever he demanded. And there's an additional testimony of the defendant that's also related to this. The defendant testified that he never disclosed this, quote, affair because he wanted to protect Ariel's reputation. That was his testimony. That is not the truth, or that's not the truth in the state's mind, and it's not the truth according to Ariel's statements that have been disclosed to defense that the court limited out. What the defendant was telling Ariel when he was demanding that she have sex with him was that if she did not comply, he would tell everybody about this affair. So when defendant testifies he didn't tell anybody about the affair because he wanted to protect his reputation, that's not the truth. And essentially what defendant was actually doing was holding this over her head to enforce his sexual demands. So we do believe that these two statements that the defendant testified to yesterday clearly make this evidence that was limited out relevant. It, not including this evidence, gives a completely incomplete picture to the jury. It gives not even half the story. So we do believe that we should be allowed to cross-examine the defendant on these issues. Additionally, the defendant introduced character evidence. The defendant introduced evidence of his character trait of meticulousness. According to the Hawaii Rules of Evidence, the state may rebut that character trait. The proposed rebuttal evidence is further evidence of defendant's controlling characteristics, which have been limbed out. These controlling characteristics actually include these sexual coercion demands. So this is actually, these two things are also all connected. But it also includes the defendant's prior spying in his last marriage, the prior viewing of the prior iPad that he had that would view his ex-wife's all of her text messages. We believe that that's now relevant to rebut the claim of meticulousness, or to, not exactly rebut, but to essentially provide the entire character trait that this is halfway referencing. So the position is the defendant is given some picture of this character trait, and we need to be able to rebut it by bringing in the rest of it. Also, with regard to character evidence, I also believe that defendant's testimony that he didn't disclose this affair or tell anyone.
I'm sorry, that he what?
That he didn't disclose this affair or tell anyone in order to protect Ariel's reputation. That counts as good character evidence that the defendant was trying to introduce. That's defendant testifying about his good character. So we should be allowed to rebut and get into the sexual coercion for that reason as well. So those are all the reasons and the things I want the court to revisit and consider that should be open for cross-examination.
I have a question with respect to the allegations of prior spying and the other iPad. What form would, other than just cross-examination, what other form would that come in?
The state did have Ms. Patella on the witness list, but the intention at this point is to limit the evidence on it to cross-examination.
Thank you for answering the court's questions. Mr. Otaki, do you have any response?
Yes. So, we dealt with these issues, very deeply and spent a lot of time on them in motions in limine and in the court rule. Obviously, we were hypersensitive to the court's motions in limine, and we contemplated the court's ruling. We obviously know the risks of how doors can be opened, and we deliberately steered clear of these things. So, for example, when we talked about how therapy turned into something else, he just said that therapy turned into other things. So the point is, we deliberately steered clear of these things to not open the door. And this is an extreme stretch and obviously a last-ditch effort by the prosecutor to get into things that the court has ruled should not come in. So let me just address these things one at a time. I'll talk about the first thing, the meticulousness. I don't know what he's talking about, to be honest. Character evidence under the rules comes in through reputation or opinion testimony. Obviously, we didn't do that. You have to also look at the context, okay? Ariel brought it up in her case about Dr. König was the one, in her testimony, Dr. König was the one who handled the finances. And trying, I guess, potentially inferring that he was, for whatever the case may be, they brought that up in their case. So he was just addressing that. I think the question was, Ariel said that you handled the finances. Why was that? And I think he said, I'm just, an organized, meticulous guy, right? So it was tied to why he was doing the finances. So, and the reason why we also know that this is, what's the right word? Not a genuine attempt here. If you really think about it, the character of meticulous is something that helps them. That he's maybe a meticulous planner of a murder or whatever, right? It doesn't help us to show he's meticulous, right? So that's how you know this is a false attempt here, because how does it hurt their case that he's meticulous, right? It doesn't. It helps their case, but he wants to use it to get into these things that the court has already ruled out. So, just because he said he was meticulous doesn't then open the door to his, to character evidence to rebut that, number one. So that's that. The part about when he was talking about what Gianna said or thought, it was in context to, again, something they introduced in their case, which is the audio recording. So he has a right to explain why he got the audio recording. And that's what he explained was in his head. He wasn't saying, he doesn't know what Ariel was talking to Gianna about. He doesn't know that. He just assumed that when that was being said to him, that's why he thought, well, maybe she's saying untrue things to Gianna. So I want to and others. So I want to record her in case, I need it in counseling or to show her that, to show these things. That's what was in his head. The issue isn't what she was really saying to Gianna. The issue is what was in his head as to why he got the audio recorder. So in no way, shape, or form should that open up the door to, again, under 403 and other rules of evidence, these allegations of sexual coercion, which obviously we have always disputed and have, taken a position that that's inaccurate. But so we were very cautious to steer clear of these things. Now, so, so that's what I say, Your Honor. This is very dangerous territory. We were very cautious to not open the door to these things. And he was talking about why he did the finances, right? Because he was meticulous and organized. Now, that doesn't then open the door to, it wasn't character evidence for the sake of bolstering his character. It's a character that actually helps the state, not us. But we're explaining something that Ariel said, that he's the one who did the finances. And we're also explaining, that, that's why he did it. So I'm not sure what the court is thinking on this. I'm happy to address any thoughts the court may have, but that's our position.
Thank you.
A lot of rambling there.
I have a couple of questions.
Sure. What we didn't address right there with Mr. Taka's arguments, and I'm sure the court will give him a chance to address this as well, is defendant's claim on the stand when he testified that he didn't tell anybody about this emotional affair because he wanted to protect Ariel's reputation. I want to make sure defense has a chance to
I appreciate it.
explain that as well.
Yeah, I appreciate it. So when he was talking about that, that was early on, right? When he was saying, we were talking about it in San Luis Obispo, and we were considering having her move out, but we didn't do that to protect her reputation. And when we got back to Maui, I didn't tell anyone for the sake of the kids and everyone else. So that was long before any of these allegations of sexual coercion came up. That was right after the discovery of the affair in San Luis Obispo and right when they got back to Maui. It was that time period in December 1st, December 8th. If you look at the notices they filed, the allegations, which again we refute, of sexual coercion came later in December. So he was saying when he got back, they decided that she wasn't going to move out in San Luis Obispo to protect her reputation. And when he got back, that's what happened. So that's number one is and again, under 403, it's the very reason he kept this stuff out. It is incredibly highly inflammatory. It's going to create a trial within a trial. And it's the exact reason he kept it out. And we were cautious to not try to somehow open the door, which we have not. I mean, we can also address things they brought up in their case that's, can coexist with your ruling. And that's what we did.
I think you said you had a couple questions, so let's move on to this.
Let me start with my questions, and then you can rebut anything that you wish. With respect to the rebutting the characteristic of meticulousness, I understand the avenue of admissibility under Hawaii Rule of Evidence 404A1, where if the defendant does make a character trait that is offered by the accused, the prosecution can rebut the same. So if the character trait is in fact meticulousness, how does what the state wants to get into actually rebutting that? Because you're talking about prior spying, right?
It does. Meticulousness is the way that the defense has been trying to characterize what the defendant was doing in the months leading up to the crime scenes, right? They're trying to say that the defendant is meticulous, and that's why he's looking up all of these old tax information. That's why he's looking up his wife's old pay stubs from several years ago. He's looking up all these things. But to rebut that, it's not meticulousness, it's a need for control. So that's where this is coming from with regards to that.
Thank you for clarifying.
And again, just the only thing I'll say again is that only came up because they asked Ariel who did the finances. And so it was tied to why he did the finances. And it was a brief thing he said, because I'm organized and meticulous. So I kept track of the finances. To now say that opens up the door to somehow getting into all this stuff is just honestly, Your Honor, it should not even remotely get close. The other thing is, and again, Your Honor, I bring this up, right? The rule I think you're talking about, right, is I'm sorry, were you talking about 608?
No, 448.
Okay, 1 second.
Yeah, I think the prosecutor's mischaracterizing what he's attempting to do here.
Okay. 1 second.
We heard from the direct examination of Dr. König right there. He's a radiologist in Hawaii.
Right. So again, we weren't offering a character trait of meticulousness. I mean, we were talking about why he did the finances. And, you know, the character evidence, like I talked about, it comes in through, you know, opinion testimony, reputation testimony. We weren't, you know, of a pertinent trait, right? Like we could have called someone and said, you know, do you know him? Do you know him well enough to form an opinion? Do you know him well enough to know what his reputation is? What is your opinion on his characterness for violence, or whether he's a calm person, right? We didn't. That's
right.
offering a character trait to a pertinent.
Thank you. I said that wrong.
Character.
Anesthesiologist.
I mean, to a pertinent trait. That's not what we did here. You know, I mean, to suggest that after they said he does the finances, and I asked him why, and he said, "Oh, because I'm just an organized, meticulous guy." Then now that opens the door to all these allegations of sexual coercion and I mean, that's
They're rebutting the
on
reason that he
multiple
kept the
levels,
lid on
but
it.
not the least of which is 403, which is why he kept this out to begin with. Yeah, and again, we're not. So it should stay out on. I mean, it's incredibly prejudicial to allow in these false, what we believe are false allegations of sexual coercion, simply because he said, "I do the finances because I'm meticulous."
I believe they're saying it's because he said he didn't tell anyone because he wanted to save a reputation, when the real reason the prosecutor is trying to introduce is because he could use that over her to coerce her sexually. So I think it should be admissible as rebuttal evidence.
There's something that I thought of as we were talking there. And this is with specific regards to the character evidence part, the meticulousness, and the need to rebut that. I'll use an analogy. Let's say a defendant, we're not talking about this case, just in general, introduces character evidence that, hey, he's kind of a punchy guy. When in fact, the defendant has 25 prior assault convictions. When they introduce this minimizing character evidence, the full rest of the character evidence becomes relevant. That's the analogy I'm kind of trying to use to make sense of this. Does that make sense? That's what the state's argument is, at least.
That is something already.
Okay, just want to add that. And again, I believe the defendant's statement that he was trying to protect Ariel's reputation is completely different than the character evidence.
Then bring that up.
But it is significantly different.
It's not really character.
That was not offered as character evidence. This is just evidence that the state should absolutely be allowed to impeach.
I think you're confusing the judge by bringing up his
Just the
character.
last thing I'll say, Your Honor, I apologize. This is the rule I was looking for earlier. I thought it was in the 600s, but 405, right after 404. I'm sure you just read it, right? So that's how you offer character evidence. In all cases in which evidence of character or a trait of character of a person is admissible, proof may be made by testimony as to reputation or by testimony in the form of an opinion. We didn't offer opinion or reputation testimony under 405, so you don't even get to this 404 analysis. But I think you understand our position.
I agree with the defense on this, but I think the prosecutor's just arguing the wrong basis.
With respect to the position of the state that the proverbial door has been open to evidence of past sexual coercion on part of the defendant when he explains that a witness referred to him as a monster.
I think he has opened the door.
Or that he was trying to show his good character by not disclosing the affair to enforce his sexual demands on his wife. The court finds that while it may knock on the proverbial door, it's not open. And even if it was, the court's still concerned about the prejudicial value of the proposed cross-examination evidence under Rule 403. The court does find allegations of sexual coercion to be highly prejudicial. And
Highly relevant,
while
though.
there is probativeness here.
That's weird.
The court still finds the prejudicial value to substantially outweigh the probative value of the evidence. With respect to the prior spying on the iPad, the court is going to allow cross-examination on those specific instances of conduct. The character trait is called meticulousness, but what it really is explaining is the lack of controlling environment or behavior that defendant has exhibited, i.e. that he's peaceful. And I understand while it creates the impression, it doesn't have to offer the trait, but if it creates the impression as argued by the state, it does open the door under State versus Brooks, which is 123 Hawaii 456. It's a 2010 case. And on cross-examination, it can be inquired into relevant specific instances of conduct. So the court does find an avenue of admissibility under Rule 404A and 405A for the prior spying. And the court does not find, contrary to the sexual coercion allegations, that the prejudicial value substantially outweighs the probativeness. That's the court's ruling.
Can I just be clear? Like,
Yes.
what exactly are they allowed to get into? Prior spying, like
On the prior iPad, is that correct?
No cross,
That is correct. This was in
on
the state's motions to eliminate, so it's identified there. It was the fact that in his prior marriage, the defendant used an iPad to spy on both his daughter as well as his wife. And it's the similar way that he described he did Ariel's phone in this case. It was actually a little more complex. He basically mirrored the other people's phones onto that iPad so we could live view what they were saying and see their emails and things like that. So that is that type of evidence. Before we get to the end, I'll have a clarifying question as well, but I don't know if we're finished with this issue quite yet.
So just so I'm clear and the record is clear, because they brought up in their case that he did the finances, and he said, I did the finances because I'm a detail-oriented, organized, meticulous person. Now we can get into from years and years before allegations that he was spying on his ex-wife.
No.
Yeah, that's why, I mean, that's what it sounded like.
It's not because they got into who brought up the finances. It's because when the word meticulous and taking care of the finances and dealing with all of the insurance and all the investment accounts, that creates the impression that defendant is not controlling, not having any coercion over the victim in this case. The impression is that, for lack of a better word, he's peaceful and not aggressive with respect to that coercive environment. That opens the door to whether or not it truly is meticulousness or something else. And I understand the rebuttal.
Can I just ask a clarifying question?
Please.
Isn't it by saying I take care of it because I'm meticulous and organized? Isn't that kind of saying that because he has control over it? So I don't understand how I'm not, trying to argue with you, but I don't understand how that is trying to imply that he's not controlling by saying I'm meticulous. That's why I do the finances. That's the part maybe I'm missing. Like how does that paint a false picture that he's not controlling? Like someone who does all the finances, all the taxes, all their life, that's kind of controlling of the finances. So I don't understand how now we're saying, oh, that shows he's not controlling. So now we can show that he's controlling. I mean,
Controlling of only the finances versus controlling of the behavior in the relationship.
what was at issue is who did the finances and why.
You had a clarifying question, Mr. Martin.
I do, and this is on the second issue we were discussing with the regards about the sexual coercion. At the motion to eliminate hearing, the court did rule sexual coercion is out, and I understand that it's still the court's ruling. The court did indicate at the motion to eliminate hearing that the defendant's sexual demands were relevant. So I want to confirm that is still the court's ruling.
That is, and that also came out on state's case in chief.
Okay, I just want to confirm that I can still go into that.
Yes.
Well, and I'm just, again, we're going to be in a position where now what, he answers that and now we open the door to everything else. I mean, we have to be able to answer things they raise without it opening the door. Okay, so I understand your ruling, but I'm just also, and he wants to ask those questions. He needs to be able to answer it and explain it. And I know what's going to happen. Then he's going to say, oh, judge, it opens the door to all this other stuff again. So I'm just saying, like, if he's going to ask these questions and he needs to be able to answer them too, out of fairness. And it's not fair where he cannot answer it, or else if he answers it now, he opens up all these other allegations. So,
I understand.
I'm just.
And to get to the specific part, so we can all be clear, to make sure whether I do ask the question or not, I can get into the sexual demands, or the demands.
With Ms. Ariel König?
Yes.
Yes.
I guess, question then that would be relevant to the defendant's testimony yesterday was whether he was holding the knowledge of this affair over her head while he made those demands. And I'm asking for clarification here. I'm not asking for any further argument about whether I should get into it. I'm asking for the court's clarification.
That was excluded in the motions in limine. I don't know why we're relitigating all the motions in limine at this stage of the trial.
I don't think we resolved that.
Your Honor, you said anything to do with using allegations of sex as coercion was not coming in. That's exactly
That's
what we're
wrong.
all trying to do.
No.
It's a wrong ruling by the judge. In fact,
With the prior partner.
No.
maybe the defense thought they could
With-
bring that.
With Ariel König, you said any allegations that he was using sex as coercion as a way to was not coming in.
And I agree with that.
That's right.
That was
Thanks for reminding me.
It's directly
So I
tied
wanted-
to him trying to control her to the extent he wanted to end her life. So all that's part and parcel of the same.
Clarification for the court and putting on the record whether that question would be in violation of that term.
It would.
Okay. Thank you for
I'm
the
sorry,
clarification.
it would be allowed?
No, it would be violative.
Oh.
Violative of the limiting rule.
Thank you.
Thank you. That's all I was looking for is the clarification.
Because that's the coercion issue, right?
Okay, understood.
Anything else we should take up?
Not, I want to raise the issue. I don't think it's going to be an issue on cross. It might be in closing about tailoring.
100%. I was going to raise that issue too.
Do you want to talk
That there should not be tailoring questions or argument.
Or there shouldn't be. There shouldn't be questions and arguments that's tailoring.
Correct.
Isn't that the current case law?
Absolutely.
The current case law is that general tailoring is not allowed. Tailoring about the defendant's presence at the trial is not allowed. Tailoring about the defendant's access to discovery is not allowed. But the defendant in this case used a very, very specific set of words when he testified yesterday. And I think the three of us all know what those words were.
I have no idea what you're talking about.
Who was the defendant testifying that he was under extreme mental or emotional distress?
Okay,
Are you asking if you can get into that issue of cross-examination?
I would like to ask whoever you heard those words.
I think you can ask them.
Bad sound here. Have it up
He said,
all the
I'm
way.
sorry, he can or he cannot?
He can.
Cannot.
Can. CAN. Can.
He can ask where he heard the words
Sure.
severe emotional distress.
Yes. Anything else before the jury comes in?
Nothing.
All right. If the jury's ready. you can come.
Actually, I need a second, given the court's new ruling. If I can send to my client.
Okay, then we'll recess and we'll go off record.
Oh, Your Honor, can we step off?
All right, so the prosecutor wants to bring up in this motion outside the presence of the jury here. The jury's not been brought in today. They're showing up at 10 o'clock Pacific time, where we do have my brother John there in the courtroom. And he just happened to be out there in Hawaii a couple of days ago. So he thought this case came up on his feed. So he decided to go check it out. Leslie and I, meanwhile, have been following it here in San Antonio off and on. And so I watched most of the direct examination yesterday with this defense attorney, the one we've seen here. And it was really painful to watch. I mean, it was really terrible job by him, because he kept on interrupting his client, and sometimes his client was interrupting him. And yes, he was doing a lot of leading. He was basically feeding him information, as Leslie would call it. And I thought that was very appropriate, because it just was very difficult for also a court reporter to be able to follow this, because it was constant interruptions, and it was very much something that you'd think a judge would intervene and help protect his court reporter. But this judge didn't do that. He just let it go on and on. Seemed like hours on end. And so it was like very torturous to listen to. So I do think that, it does hurt their credibility. I've always said that you have to act with dignity and respect in the courtroom and have professionalism and honesty. And so that cuts against the professionalism and likability. I say likability is sort of the foundation of how you have to come across in a courtroom. And this defense attorney comes across too aggressive, too smart alecky, and I think it hurts his credibility and likability significantly. So anyway, I just think that yesterday his testimony was pretty much, he was dead in the water. I thought that his credibility and the way he explained things was just non-credible, non-believable. The jury's just like, yeah, right, I'm sure. And so yes, we also saw the son when he testified a couple days ago called the defendant instead of dad. He's not seen as dad since he got arrested, and so he did come across very controlling the way he testified yesterday. He used the word safety a lot, like he did certain things for safety reasons, and so it's not looking good for the defense at all. I would say you could get in a he said she said knockdown drag out argument and who started what on that trail that had a cliff near it. And so they could leave you to wonder, who's telling the truth here? But I think the things that really work against the doctor in this particular case is the fact that he called his son to say he tried pushing his wife off the cliff. And so that son came across extremely credible. And it's not the son of Ariel, the victim. It's actually, she's a stepmother to this son. So in any case, I think that's what really is the driving thing that just buries the defense. And then what his story was yesterday, that he basically had to use a rock to hit his wife over the head, and because she was grabbing his testicles. I mean, that just sounds so ridiculous. I don't care how much a beta male you are, you're not going to take a rock and hit a female, your wife that you love, and it's her birthday, and you're taking on this loving hike. And anyway, the way the whole thing went down, where they got in a fight over this emotional affair, co-worker of hers, is just really, it's really laughable. Like I've seen a comment here mentioned. So, and then you leave her behind with all that blood coming out of her head. It's really a gruesome scene, and she even had a fracture of her thumb trying to block some of the rock blows to her head. So, and he did introduce yesterday that he was referred to as a monster by his wife and also her best friend. So I thought that was interesting that they brought that up. And so, yeah, it's not going good for the defense. I understand the defense counsel is mostly a PI attorney, he's not a criminal lawyer, but as a trial attorney, you need to make sure you don't do a lot of stuff he's doing to be effective. So I think he's lost a lot of his effectiveness. He is being aggressive, which I like to see for a defense attorney. This defendant is rightfully expecting a aggressive defense, a formidable defense. So I think the defense attorney's doing that. I think just some of his tactics and techniques are not helpful. And so Trace is here. You're saying the defense is making you really angry. Yeah, I can see that. Don 64, you're saying both defense and Koenig's voices are nails on a chalkboard. That's a good way to say it.
Case number 16, State of Hawaii versus Gerhardt König, 1 CPC.
Hopefully this cross is not going to be too long.
373 for further
I don't think they need to have any lengthy cross-examination.
Ladies and gentlemen, Deputy Prosecuting Attorney Phil Garner to the state, also present is Deputy Prosecuting Attorney Franklin Don Carlo Jr.
Morning again, Mr. Garner. Morning again, Mr. Carl.
Morning, Judge.
Good morning, Your Honor. Good morning, ladies and gentlemen. Thomas Otake, not the Dirks, on behalf of Gerhardt König, who is present.
Morning again, Mr. Otake. Morning again, Mr. Gerhardt. Dr. König, morning again.
Morning, Your Honor.
All you can be seated. Ladies and gentlemen of the jury, good morning to all of you. Welcome back to courtroom 15. I apologize for the delay. The morning calendar got a little bit away from me, so I appreciate your patience. We'll continue on with the presentation of evidence. Dr. König, if I can have you come back up to the stand and resume your place on the stand.
All right, so they've had after the trial yesterday to get him prepped on cross-examination based on what he testified to yesterday. He had no real emotions yesterday, some fake tears
Yes.
that I perceived.
Whenever you're ready, you may begin your cross-examination. Thank you.
here we go. Cross of the doctor.
Good morning.
Good morning.
On March 24th, 2025, you were married to Ariel König, correct, Dr. König?
Yes.
You and Ariel got married in 2018, is that right?
Yes.
You dated for 1 or 2 years before getting married, correct?
Yes.
When you met Ariel, you were working as an anesthesiologist in Pittsburgh, right?
Yes.
And yesterday you described what anesthesiology is, correct?
Yes.
You used very technical terms, right?
Yes.
Maybe the more plain term is that you are the one who puts people to sleep before an operation, correct?
That's what people typically call it. Yes.
It's not actually sleep, right?
It's not actually sleep, right?
But you're the one that essentially puts them out, and then after the operation, they wake up again, right?
Yeah. That's part
Anesthesiology
of
is a
it.
very specialized field of medicine, correct?
Yes.
You decide.
Second. Could you just put the mic closer and keep your voice up? So everybody can hear. Thank you.
Prosecutor needs
Okay.
to talk louder.
You decide how much of each anesthesia drug to give a patient, correct?
Yes.
You give too little of the drug, and it's possible the patient could wake up during the surgery, right?
Yes.
You give too much, and the patient could never wake up at all. Is that right?
That's correct.
Ultimately, you're the one with that control, right?
Yes.
Now, you first became an anesthesiologist in Pittsburgh, again, right?
Yes.
And you testified yesterday that money is the main reason you moved to Pittsburgh, correct?
No.
Objection misstates his testimony.
Overall, answer stands.
You testified that the cost of living in Pittsburgh was very important to you, correct?
Yes.
And money is very important to you, right?
No, I wouldn't say that.
Your testimony today is that money is not important to you,
Not very important to me.
not very important. Okay. Now, while you were dating Ariel in Pittsburgh and eventually married to her, right?
Yes.
Okay. She went to graduate school while you guys were in Pittsburgh, correct?
That's right.
And she ended up working in the nuclear engineering field, correct?
She was working in that field when I met her.
And then near the end of 2022, you and Ariel decide to move to Oahu, right?
To Maui.
I'm sorry, Maui. And you moved and you closed on a house at 19 Pu'uehu Place on December 14th, 2022. Is that right?
I don't remember the exact date, but it was around that time. Yeah.
The sale price of that house was $1.5 million, correct?
That's right.
And together you and Ariel had a down payment of $300,000, correct?
That's right.
And when you moved to Maui, you had a job lined up, right?
Yes.
That was at TAMG, correct?
Yes.
And TAMG is a group of anesthesiologists that provide services to all the different hospitals on Maui, correct?
The one hospital and surgery centers and some outpatient clinics.
And actually on the island of Maui, TAMG is the only provider of anesthesia services, correct?
We're the only big group of anesthesiologists. There's some independent anesthesiologists and I believe one CRNA that flies over to sometimes work at a plastic surgery outpatient center.
TAMG is the biggest group in town, right?
Yes.
And because of that, TAMG can set the prices, right?
No. We just went through contract renegotiation with the hospital, and we had to use research, based on salaries across the United States in comparable locations.
And that salary got you to your salary was then end up being between $500,000 and $6,000 per year. $500,000 and $600,000 per year, correct?
I never got to work under that contract for a full year. When I moved there, we were making between $300,000 and $400,000 a year.
Okay, so you were making $300,000 to $400,000 a year while you were after you moved to Maui from January 2023 to December 2024.
Yes, that's correct.
And Ariel found a contract position working remotely for a company called TerraPower. Is that right?
Yes.
Ariel made less than $200,000 per year, correct?
Yes.
You made substantially more money than Ariel, right?
Yes.
Okay. On March 24, 2025, you and Ariel came to, or were on Oahu, correct?
Yes.
And you came to Oahu because it was Ariel's birthday weekend, is that right?
That's right.
And Ariel's birthday is actually March 24th, correct?
Yes.
You bought the airline tickets for the trip, correct?
Yes.
And of course, you bought round trip tickets, right?
Yes.
So you were scheduled to go back to Maui on March 25th, 2025, correct?
Yes.
You booked the hotel for the weekend trip, correct?
I did.
You sent spa information to Ariel before the trip, right?
Yes.
And then you booked the spa, correct?
Yes.
You did not send Ariel electronically any information about the Polipuka hike, isn't that correct?
I don't think I did.
We're gonna go back in time a little bit, Dr. König. So yesterday you testified that you started to become suspicious of Ariel in October 2024. Is that right?
Yeah, that's right. Some red flag behavior in like late September probably, but it was probably mostly in October when I got really suspicious.
Well, you testified yesterday that you only became suspicious in October after you heard a phone call. Isn't that right?
Specifically about Jeff Miller. But I was suspicious about her phone behavior prior to that Kauai trip in October.
And once you became suspicious, you went into what you called detective mode. Is that right?
Eventually.
Detective mode for you started with logging into Ariel's WhatsApp account, correct?
No. Detective mode started with me asking her why she's on her phone all the time.
And you logged into Ariel's WhatsApp account, correct?
Eventually.
And you would watch the messages every day, right?
I watched them for 48 hours.
You watched these messages as they were being sent, correct?
Some of them if I was at the computer when they arrived.
And the laptop that we've all seen in this so far, States Exhibit 240, I'll put it up on the screen.
Is in evidence.
Yes. Okay. Dr. König, this is your laptop, correct?
That's correct.
Okay.
Yeah.
So you logged into Ariel's WhatsApp from this laptop, correct?
Yes.
And you saw the messages between Jeff Miller and your wife, correct?
I did.
You downloaded those messages, correct?
Yes. Not from the laptop. I downloaded the messages from her phone, and then I saved some screenshots on the laptop.
We're going to publish now States 118, which is already in evidence.
Yeah. This looks really bad. Trying to live spy on your wife.
Okay. We have States 118 on the screen, Doctor. This is an email you sent to Bryant Bunting, correct?
Yes.
Okay. And the first attachment to this email is called Screen Time and Deleted Messages, correct?
Yes.
I'm going to go to page 2. This is the first page of that Word document, right?
Yes.
This is the Word document you created while in detective mode, right?
Yes.
And in this document, that picture at the top, and I'll zoom in, that's the screen of Ariel's phone, correct?
Yes.
You logged into Ariel's phone to take that picture, correct?
Yes.
You entered the passcode into her phone, right?
Yes.
You opened the application to show the screen time, right?
Yes.
And then you took this photo.
Yes, I did.
And then you wrote your thoughts underneath, isn't that right?
Yeah, I took notes.
You took notes, as you would do in detective mode, right?
Yeah.
Your first notes were calculating the number of hours she spent on the WhatsApp app, correct?
Yes.
You calculated it and you did some division based on how many work days there were, right?
I did.
And then you speculated about phone calls, correct?
Yes.
Move on to page 3. Page 3 of this shows other screenshots you took is right of Ariel's phone, correct?
Yes.
And this is as other screenshots of every app that she was using, correct?
The Screen Time app keeps track of all of the apps that you use, and I think there's probably more, but I just did the first 3 pages.
You didn't stop with WhatsApp, did you?
No.
You looked into her entire phone, correct?
No, I looked it down to 3 pages of the Screen Time app.
You were in detective mode and you didn't look through her actual text messages?
I did look at the text message threads on her phone.
You looked at the text message threads on her phone, right?
I did not look through all of her text messages. I opened the texting app to see if there's anything that looked suspicious there. There wasn't, but really I went straight to WhatsApp because that was the most used application.
You looked through her emails, correct?
Not at this time. I did end up looking through her emails later, mostly with her consent. Like as I'm seeing her on her phone and she's writing an email, I'll be like, "Hey, who are you emailing? Can I see?" And then she'll show it to me.
This was after then you confronted her, correct?
Yes.
Okay. Now let's focus on this part of the detective mode for now. You looked at her phone calls, correct?
I looked at the phone calls that she made through WhatsApp. I didn't actually look at the phone calls on the phone.
Okay. So you're suspicious of your wife for 2 months already, right? When you do
Yes.
this.
Yes.
And you look through her WhatsApp, correct?
Yes.
You don't look through all of her text messages, correct?
Correct.
And you don't look at her phone calls, right?
Right.
Doesn't sound credible. I think he's obsessed with seeing all of it.
These are photographs of the screen of the phone, correct?
Yes.
Okay. So you didn't take a screenshot and send it to yourself, right?
Not of this. No.
Not for these photos.
Mm-mm.
Ariel didn't know you were taking these photos, isn't that right?
No.
Okay, we're going to move on to page 4 of this document. I'm sorry, we're going to move on to page 6 of this document. Now, actually, I'm sorry, we're going to just go to page 4. At the top of this document, this is still the Word document that we were talking about, right?
Yes.
Okay, it is called, again, Screen Time and Deleted Messages, right?
Yes.
So most of the page we're looking at is what you copied and pasted or downloaded from WhatsApp, correct?
Yes.
But the very top of this page says deleted messages from Sunday 12/1, parentheses, all deleted, right?
Yes.
You wrote that part.
I wrote
correct?
that part. Yep.
Okay. So you were able to see and record all the deleted messages from Sunday, December 1st, 2024, correct?
Yes.
And you read these messages, right?
Yes, I did.
You read them and starts out, we'll go for the first couple section. Mr. Miller says, good morning, right?
Yes.
He says, I hope you're getting some good sleep, right?
Yes.
And you talked about his sleep, correct?
Yes.
Then Ariel says, good morning, right?
Yes.
There's nothing sexual in these messages, is there, Dr. König?
No.
This is 2 people saying good morning to each other, right?
Yep.
And you were upset because in your mind, this is what spouses do, right?
Say good morning. I wasn't upset that they were saying good morning to each other. I was upset about the entire relationship that they had.
You were upset that they were talking at all like this.
Not just about good morning, about the whole thing.
About the whole thing, okay.
Yeah.
You talked about that they were sending each other links for music, right?
I did talk about that.
And those links are actually contained later on in this document, correct?
They were in earlier conversations. I'm not can't remember where they are in the document.
We've moved on now to page 5 of States 118. Actually, we'll just keep moving forward. Okay, so we're on page 6 now, and you included a screenshot of the WhatsApp now, correct?
Yes.
And part of the screenshot, we'll zoom in, is your note at the very top says these are deleted messages from Tuesday 12/3. Correct?
Yes.
Okay, so far at this point in detective mode, you've looked at messages from 12/1, correct?
Yes.
You've also looked at messages from 12/2, correct?
Yes.
And now you're on to December 3rd, right?
That's right.
And December 3rd is the day that Ariel is going to San Luis Obispo, correct?
Yeah, she was actually not arriving until the next day, but she was leaving Maui on that day.
And then she had a layover in Arizona, correct?
That's correct.
And in this photo we're looking at here, Ariel is texting Jeff Miller about being on the plane and getting ready to go to sleep, correct?
Yeah, that's one of the messages that's on there. So this is just the messages that were not deleted by the end of the day that day. So there's a lot more messages that happened during the day, but she had deleted them in different parts of the day. But
So a different
yeah,
day they were
the
deleted.
last message on this page says, "I hope packing went well. I'm on the plane and ready to sleep."
And then your notes about what you think about these messages continue onto the next page, correct?
Yeah, this is live.
Not really what I think about it. So I was keeping notes of when I took the screenshots and what I was seeing at the time, because the way the screenshots work on the computer is that I have to basically copy and paste the screenshot, and that takes some time. So sometimes in between me copying the page and pasting it into the Word document or somewhere else and saving it and going back, she had already deleted other messages. And so I would just take notes and say, like, this message was sent before I could screenshot it, or and then sometimes she would delete some of the messages and then later she would go back and delete more. And so it created a very confusing bunch of screenshots that I had. And so I took notes to kind of help myself piece it back together at a later time. And if that makes sense.
Yep.
Not really my thoughts about what I was thinking about the screenshots at the time. Do you understand? I was just taking notes of like the order in which that they came in, and so I can make sense of the screenshots later.
And naturally you were upset as you did this, right?
I had a lot of different feelings at the time, suspicious and sad and not happy.
Suspicious, sad, not happy, upset?
Yeah, that's probably fair to say.
Okay. All right, we're going to take this exhibit down. And again, this exhibit you actually emailed to a Mr. Bunting, correct?
Yes.
And Mr. Bunting was at the time your best friend, right?
Yes.
And
One of my best friends. Yeah.
Mr. Bunting was married to a woman named Gianna, correct?
Gianna. It's spelled with a D, but she's Brazilian.
Okay. So he was married to a woman pronounced Gianna, correct?
That's correct.
And Gianna was Ariel's best friend, right?
One of her best friends. Yeah.
So you send this email to Bryant Bunting on December 4th, 2024 at 3:33 p.m., correct?
Yes.
And that's before you leave for this trip, correct?
Yes.
And this is a trip that's going to include you, Ariel, Bryant, and Gianna, correct?
Yes.
You also had 2 other attachments to Mr. Bunting, correct?
I don't remember if you could show me.
All right, we'll publish page 1 of this exhibit again.
Sorry, what number exhibit?
This is States 118. Okay, and we'll zoom in on the middle of the page to attachment names. There were 3 attachments to this email, correct?
Yes.
Okay, the first was screen time and deleted messages, right?
Yes.
And that's the document that we've gone through so far, correct?
Yes.
The second document is some saved chats with pictures, correct?
Yes.
And you reviewed those chats, right?
Yes.
And you reviewed the pictures, correct?
Yes.
Nothing sexual in those chats, right?
No.
Nothing sexual in those pictures, correct?
No.
And the last file is chat.txt, is that right?
Yes.
And this is what you actually download from WhatsApp, correct?
Yes.
Okay, so when you download a chat from WhatsApp, you get a file with a TXT, right?
That's correct.
Why is he saving and downloading all this? Is that going to be asked?
Now, you said already that you were upset when you were reading these messages, correct?
Yes.
You were upset that she was talking about her personal life with another person, correct?
Yes.
You're upset that she was talking about her kids, right?
Yes.
You're upset that she was talking about the kids putting stuff up on the Christmas tree, right?
Yeah. I mean, in the context of the whole conversation. Yeah. I was upset about that.
And you're upset that your wife was keeping these messages secret from you, correct?
Yes.
No bullying
So,
comments,
Before
please.
you confronted Ariel, you emailed these documents to your friend Brian, correct?
That's right.
And you actually emailed these documents to Bryant, before you even got on the plane, is that right?
That's right.
So before you even talked to Ariel about this at all, you were already telling Bryant, is that right?
That's right.
You didn't give Ariel a chance to explain herself about these, correct?
Not before I talked to Bryant that day, no.
And you also told Gianna, correct?
I did tell Gianna the next day that I was suspicious that she's having an affair.
So you told Ariel's best friend about your suspicions before you told Ariel, correct?
A few minutes before, yes.
That's
You did
weird.
that because you wanted Gianna and Bryant on your side, correct?
That's not correct.
You wanted Ariel's best friend to hear about this emotional affair from you, right?
No, that's not correct.
You didn't want Gianna to hear about this from Ariel, correct?
That's not true.
Well, you told Gianna first, isn't that right?
That's right.
You wanted Gianna and Bryant to judge Ariel, correct?
That's not true.
You wanted to isolate Ariel from her best friend, isn't that right?
That's absolutely not true.
So after you tell your best friend and Ariel's best friend about this, that's when you actually confront Ariel, correct?
That's correct.
And you're upset, right?
That's not the primary feeling at the time. I was feeling a lot of other feelings, but I was also upset.
You're mad, right?
I was not mad.
You were not mad when you confronted your wife about these messages.
I was upset.
Okay. It's natural to be mad in this sort of situation, isn't it?
You could be.
And in this confrontation, you called Ariel a lying bitch, right?
I did call her that at some point, not in the beginning of the disclosure.
You called her a whore, right?
I did call her a whore at some point. Again, I think within like the first 24 hours and not during the initial disclosure.
And after this all came out, after you confronted Ariel, called her a lying bitch, called her a whore, you wanted her to move out of the house. Is that right?
That's right.
You used an example yesterday where you talked about somebody else moving out for about 3 months and staying in a hotel, correct?
That's right.
And that's what you wanted Ariel to do, right?
No.
You just said you wanted Ariel to move out of the house. Isn't that right?
Yeah, but you just asked if I wanted her to specifically move into a hotel for 3 months. I had no, I did not want her to move out of the house for 3 months and go live in a hotel.
You just wanted her out.
I preferred to have her move out while we're dealing with the aftermath of her having an affair.
And Ariel didn't want to move out of the house. Is that right?
We both didn't want her to move out of the house. We both decided that together after talking about it.
You just said just a minute ago that you wanted her to move out, right?
That was my preference in the beginning. And then we decided that we're not going to do that. There's
Okay.
plenty of examples of people holding contradictory beliefs. And then you talk about it and think about it and figure out which way you're going to go.
Dr. König, Ariel's children were 4 years old and 18 months old at the time that you wanted her to move out. Isn't that right?
That's correct.
No mother would want to move out of the house with their kids that age, would they?
I wouldn't think so.
But that's what you wanted, right?
I wanted her to move out of the house for us to deal with the affair, and I didn't want her to move out of the house and harm her children. I wanted both.
Now, another thing that you wanted is we wanted Ariel to quit her job, right?
That's right.
And this is the remote worker job that she was able to find on Maui, correct?
Yes,
There are no nuclear power plants on Maui, right?
that's correct.
So if Ariel wanted to stay in her career and advance her career, she had to work remotely, right?
That's correct.
If you were to stay on Maui, right?
Yes.
And once Ariel quit her job, as was your plan, she would have been 100% dependent on you and your salary, correct?
She would be dependent on our assets, which were all shared. We had a shared savings account. We had a home that was shared. We had vehicles that were shared. We had food in the house that's shared. I mean, we had a lot of things in the house, and they were all shared. We would lose her income as a family for a short period of time. She has a very good resume. She would be able to get a job, probably within a few months. But if it took a few months, we were prepared for that.
When Ariel quit her job, as was your plan, you would be the only breadwinner, correct?
I would have the only one with a paycheck coming in while she didn't have a job. That is correct.
She would be dependent on you and your goodwill to keep a roof over her kids' heads, right?
No,
She would be dependent on you and your paycheck to keep her kids fed, right?
no,
You wanted Ariel to give up her career, correct?
no.
You wanted to make sure Ariel never had contact with Jeffrey Miller again, right?
That was my strong preference, for her to not have contact with Mr. Miller ever again.
And in order to do that, you wanted access to Ariel's phone at all times. Is
That
that
is
right?
absolutely not correct.
You actually had Ariel's phone in December 2024, isn't that right?
I wouldn't say that. Like, her phone, it's at many points in time, I had her phone in my hand. I would not characterize it the way you just did.
And you
There's even more control.
monitored her communications in December 2024 after you confronted her, isn't that right?
I, on several occasions, asked to see who she was communicating with, and she would show me. And the only time that I monitored her communications was for 48 hours when I was watching the WhatsApp messages. And most of those I was watching on my computer, not on her phone.
So today you're saying you were only monitoring her communications a little bit, right?
I don't know what you mean by a little bit. I just described to you how I was monitoring her communications.
Yesterday you testified about what you thought Ariel needed to do, isn't that right?
That's correct.
You testified that she needed to, quote, proactively give up privacy, correct?
Yes,
And you also said that she needed to be okay with giving up her privacy. Is that right?
that's right.
That's what you wanted, right?
That's what I wanted.
She didn't end up doing that, did she?
No.
And that upset you, right?
Although she did do it. She did do it initially. She did it in San Luis Obispo, and she did it for a very short period of time in Maui, and then sporadically again in December. And honestly, she changed her behavior. So in January, February, March, she was not like, I didn't feel like she was hiding her phone from me anymore. I didn't feel, and I knew her passcode hadn't changed. So she was doing a lot of those things.
You knew her passcode had
Your
changed,
control, extreme
right?
control is
You just said
working.
that.
That's right.
The only way to know that is by testing it, right?
No, you could also see them put in their passcode. And when somebody's sitting next to you and they're not hiding their phone, you can easily see who they're writing, what they're saying. You can easily see their passcode. And if somebody's not worried about sharing the passcode with the person sitting next to them, you're basically showing it to them, and that's what was going on.
Constant
So
monitoring.
you watched what Ariel was doing on her phone in person, right?
Yes.
Now, another thing you mentioned yesterday is that you believed the cheating spouse needs to put in the work, right?
That's not what I said.
You testified that the cheating spouse needs to put in the work, right? You said that.
I wouldn't characterize it like that. I would not say the work. The way you're making it sound is like there's only one work to be done. The work that needs to be done to heal a relationship after any kind of issue like this involves both parties. And I was talking specifically about the part that the cheating spouse has to commit to doing. I was not saying that was the only work that needed to be done, like you're implying.
Dr. König, if we could not go into anything implied, I'm just asking you a question, okay? I'm asking you what you said.
Your Honor. He's trying to answer the questions, should be allowed to answer.
If it's non-responsive.
But that was not, he's asking questions, he's answering.
Is there an objection?
My objection is to him reprimanding the witness when all he's doing is answering the question. So that's my objection.
Overruled.
Now, you testified, I'm sorry, after you confronted Ariel about this affair, you wanted her to meet your physical needs, correct?
I wouldn't characterize it like that.
You wouldn't characterize it as Ariel being unwilling to meet your physical needs? Would you?
I would characterize that I was in a relationship with Ariel for 8 years, and we had a physical relationship, and I had physical needs as part of that physical relationship prior to me finding out about the affair, and I had physical needs after the affair as well.
Okay. And she's a regular, we're talking about sex here, right, doctor?
No, I'm talking about physical intimacy with the person that I love the most, which includes sexual and non-sexual intimacy.
You believe that Ariel should meet your sexual needs after you confronted her about this affair, correct?
No.
You don't believe that?
Your Honor, can we approach?
Sure. No.
All right, so this guy's not coming across good at all. What do you guys think? He's trying to downplay the amount of control he had over her, but all that monitoring and whatnot is not a way to have a good reconciliation because he doesn't trust her. He's constantly looking over her shoulder, looking directly at her devices. And yeah, as Tracy says here, did he show his phone and passcode? So he very much is going to make sure she does not get away with this.
Dr. König, after you confronted Ariel, you needed her to meet your sexual needs, correct?
No.
That's your testimony today.
Yes.
Ariel
No,
stopped
yeah.
having sex with you on December 24th, 2024, correct?
The last time that Ariel and I had sex was on December 24th, 2024. We did not have sex after that, and we both decided not to have sex after that.
You're upset that she wouldn't have sex with you, right?
That is not true.
When Ariel didn't have sex with you, you believe she was withdrawing from the relationship. Isn't that right?
That's not true.
Ariel didn't want to have sex with you anymore. Isn't that right?
That's not true.
Ariel was unwilling to quit her job, right?
She was willing to quit her job initially, and then later she was unwilling to quit her job. That's correct.
Ariel was unwilling to give up her privacy to you forever, correct?
Because of his control. Why give it up? The job, if he's that
Yeah, that's right.
controlling. You don't have a stable future.
Ariel was unwilling to move out of the house and away from her children, correct?
Yes.
Ariel was unwilling to have sex with you whenever you demanded it. Isn't that right?
Can you ask the question again?
Ariel was unwilling to have sex with you whenever you demanded it. Isn't that right?
I never demanded sex, so that's not right.
Now, you were 46 years old at the time this was happening, right?
That's correct.
And after you call a woman a lying bitch and a whore, it makes sense that they don't want to have sex with you, right?
Objection argumentative, Your Honor.
Sustained. You still wanted Ariel to have sex with you after you called her a lying bitch, right?
We had sex in December, and that was after we had that conversation. Yes.
You were upset that Ariel was still talking to Gianna about you, right?
No.
You testified yesterday that you were upset that Gianna called you a monster, right?
I was upset. Well, that made me suspicious of how Ari was characterizing both the affair and our relationship at the time to Gianna.
And this is after you wanted to have Ariel move out of the house away from her kids, right?
Actually, this was during. At the time that she made that comment, we were in an argument where I was asking her to move out.
At the time she made that comment. Is this the argument you mentioned on December 26, 2024?
Yes.
Okay.
That went into December 27th.
The argument went into December 27th?
Yes.
Okay. So this argument happens. You're still mad, right?
And again, I wouldn't characterize my emotion as mad. Whenever we talked, I was certainly upset, but not mad.
This argument where Ariel told you that Gianna called you a monster, this is after you told her to quit her job, right?
I asked her to quit her job. I didn't tell her to quit her job. I asked her to quit her job as part of us healing from the affair at the beginning of December. I actually didn't ask her to quit her job at any point in time after that. I had asked her to give me updates on how the job search is going, but only in like probably the first couple weeks of December. And then we never talked about it again. Like it was obvious that she wasn't looking for a job anymore. And at that point in time, we were discussing other things in the relationship. So the last time I had asked her to quit her job to help us heal from the affair was in the beginning of December.
So your testimony today is you just let this go? You just let this go about her job?
Shan misstates his.
No, I did not let it go. I put a pin in it, basically. I put that issue on hold while we were dealing with other things in the relationship.
We're going to go back in time a little bit, Dr. König, back to early December. You looked up somebody called Andrea Miller on LinkedIn. Is that right?
That's right.
LinkedIn is a social media site used for professional networking. Is that correct?
That's correct.
And you need a specific type of account or access to a type of account to find out the email for another person, correct?
I think I don't use LinkedIn very often. So I'm not sure excuse me, whose email addresses you have access to and whose you don't, without certain features of the program.
Well, on December 5th, 2024, you actually purchased what's called a Sales Navigator Core account on LinkedIn. Is that right?
Yes, I signed up for a free trial of that feature of the LinkedIn account, specifically to get access to Andrea Miller's email account or email address.
So you signed up to find Andrea Miller's email address,
Yes, I did.
right? And you found her email address, correct?
Yes,
And on December 6th, 2024, at 8:24 a.m. Hawaii time, you sent an email to Andrea Miller, correct?
I don't remember the exact date or time, but that sounds right. And yes, I did email her.
Okay, we'll put States Exhibit 108 already in evidence up onto the screen. This is the email you sent to Andrea Miller, correct?
That's correct.
You sent it on December 6, 2024 at 8:24 a.m. Is that right?
That's right.
The address too is the email address that you found from Andrea Miller from LinkedIn, correct?
Yes.
That's her work email address, right?
I don't know.
Kyndryl is a financial services company, correct?
I don't know.
In that email, you testified yesterday that the purpose of this email was simply to let Miss Miller know what's happening. Is that right?
That's correct.
And at the start of this email, that's what you do, right? You tell her about what you think about Jeff and Ariel, and you call it an inappropriate relationship, right?
Yes, that's how I describe it.
You didn't call it an affair, right?
I did not.
You didn't call it an emotional affair, right?
I did not.
You just called it inappropriate relationship.
That's right.
And then you provided her your phone number, is that right?
Yes.
You provided her your email, correct?
Yes.
And those are your contact information, so you're free to provide those things, right?
Yes.
And then you provided her with Ariel's phone number and email, correct?
That's correct.
You provided her with Ariel's cell number, is that right?
That's right.
And Ariel's personal email, correct?
Yes.
You provided that because you wanted Andrea Miller to contact Ariel, didn't you?
Mm-hmm.
I just wanted her to have the option of contacting all of us and
You're hoping
talking to
she
all of us
would.
and getting all of the information from as many people as possible so she could make a decision about what she wanted to do with this information with her family.
The only purpose for including Ariel's contact information is so that she can contact Ariel. Isn't that right?
That's right.
And you wanted Andrea Miller to contact Ariel to yell at her, right?
That's not true.
You wanted Andrea Miller to contact Ariel to humiliate and punish Ariel. Isn't that right?
That is absolutely not true.
You offered Andrea Miller the text messages, correct?
I did. All right. I don't know if I did or not. I don't think I offered it to her. I just said
You said, I can share with you what I have if
share
you
with
would
you.
like.
Yes.
Right?
Yes, I did.
You also sent Miss Miller a contact request through LinkedIn directly, correct?
That's correct.
Andrea Miller never replied to your emails, isn't that right?
That's right.
Andrea Miller never replied to you on LinkedIn, isn't that right?
That's right.
On December 12th, I'm sorry, I'm going to take the exhibit down.
You need more help
December
in boxing
12th,
in and
2024.
controlling
You ordered
Ariel.
the first of a several series of audiobooks about affairs, correct?
I don't remember the exact date, but that sounds right.
The first book you ordered was called The State of Affairs, is that right?
That's right.
And as it states in the title, it's a book about having affairs, correct?
Yes.
Mandatory reading.
2 days later, on December 14th, 2024 at 10:45 p.m., you opened a PDF file on your computer from your prior divorce proceedings. Is that right?
I have no recollection of that.
We're going to publish states 113, already in evidence.
I've had clients testify and it's turned out
Now-
well for them.
You, on December 14th, 2024, opened up a PDF file called Bank of America Amex E-Statement 2015-12-24.pdf, right?
I have no recollection of this.
You have no recollection.
Show us the actual
All right,
document.
well- Let's zoom in on the photo.
Yeah, show us the photo. You just give all this.
The file system last access date and time of this document was December 14th, 2024 at 10:45 p.m., correct?
I can see that. Yeah,
Do you agree with that?
I agree with that.
Let's go to the file path, Dr. König. This is under the username G. König, correct?
Yes.
That's your username, right?
Yes.
Your files are contained under that username. Is that
Yes.
right? The next folder is the Dropbox folder. Is that right?
That's correct.
You use Dropbox, correct?
I do.
You have a Dropbox that has subfolders in it, correct?
Yes.
The next subfolder is called JPR. Is that right?
That's correct.
That's a subfolder that you created, correct?
Yes.
That's a subfolder that means Jessica Patella Ray. Isn't that right?
That's correct.
And under Miss Ray's subfolder, or Miss Patella Ray's subfolder, you have a separate subfolder called Divorce. Isn't that right?
Yes, I created that.
You made that folder, correct?
Yes.
And in that folder, there's another folder, right?
Yes.
And that's for 2016-04 hearing. Isn't that right?
That's right.
This is a hearing about your divorce from April 2016, correct?
Yes.
And the last subfolder is supportive documents. Isn't that right?
Yes.
And in that supportive documents folder, the supportive documents are for this April 2016 hearing, correct?
Right.
These are the documents that you want to bring to your divorce hearing, right?
Yeah.
And the
It was a long
document-
time ago, but that was probably all the supporting documents that my lawyer needed for that hearing. And this was a Bank of America Amex statement from 10 years prior. So
It's a long time ago.
I have no recollection of looking at a Bank of America Amex statement from 10 years prior on this date. I don't remember doing that.
Don't remember at all.
Mm-mm. And I mean, it says file system last access. I don't know if that gets triggered if like a file is copied or something like that, because I was looking through the documents when they were presented into evidence earlier in the week, and there were a few that I did not recall accessing on those times. Many I do recall accessing.
But this one
But
about
this is-
divorce,
this is
you're
what-
saying you don't.
I don't recollect accessing that. No,
Now, on December 14th,
and I can't think of a reason why I would have.
you can't, there's no reasonable reason for you to be accessing this. Is that right?
There's no, I can't think of a reason why I was looking at a Amex statement from 10 years prior on December 14th, 2024.
This is a document that you needed to prepare for your prior divorce, correct?
Correct.
This is in the middle of December 2024, correct?
That this document was accessed?
Yes.
Yes.
Why? Why would you access that?
Now, the very next day, we'll take this one down. And we're going to go chronologically. The very next day, on December 15th, 2024, at 8:17 a.m., you viewed a January 2022 pay stub for your wife, Ariel König. Is that correct?
I don't recall that, but I that sounds more plausible that I had done that. But I don't specifically recall that date and looking at that document.
We'll publish dates 1 through 5. This is the metadata, correct? Oh, I'm sorry. This is not page 1.
Prosecutor's doing really good with exhibits here. Smooth flow.
All right, publishing page 1 of states 125.
Pulling all these up on his
Okay.
iPad, which is unique.
The last access date is December 15th, 2024 at 8:17 a.m., correct?
That's correct.
Okay. And the file path for this is looking through your 2022 taxes. Is that right?
It's ours. So we have a shared folder on Dropbox called The Big Love Party and other super fun stuff that I created when we were planning our wedding. And so this is a shared folder on Dropbox that both Ari and I have access to. And this is in the taxes folder within the shared, because I put all of our shared financial information in the shared drive that she has access to, and she put things that she wanted to share with me in it as well. And so this is in our shared taxes
Sounds good.
folder, and it's in specifically a subfolder that's for her pay stubs.
And so you wanted to look up Ariel's pay stub from January 2022, and you wanted to look that up on December 15th, 2024.
Yeah, that seems more.
The only information
More
contained in this
plausible.
document is about Ariel's pay from 1 month. Is that right?
That's correct.
Okay, it's simply just a pay stub telling you how much she got paid, right?
Yes.
Do you want me to go to the pay stub so you can see?
No.
We'll take the exhibit down. And you're looking at this pay stub the day after you're looking at this document from your prior divorce. Isn't that right?
No, 'cause I don't recall looking at that Amex statement.
So you just don't recall again?
I don't recall looking at that Amex statement at all.
You tell me when there's convenient break, Mr. Garner.
We're getting close. All right, we're going to keep going forward in time. December 18th, 2024 now. You purchased your second audiobook. Is that right?
I think you've already mentioned two. Isn't this the third then? I mean, I don't remember. I purchased many audiobooks, but I think we've already talked about two.
So far, we've talked about the state of affairs. Is that right?
That's right.
Which other book?
Oh, okay. Okay. So this must be the second one. I don't remember which order they're in, but I know I purchased multiple.
Why isn't she buying
Let's
them?
just put up the exhibit so we're not confused about the order, okay?
It's very controlling. She's not
States
seeking
106.
this help
All right, publishing
information. He's
page
pushing it on her.
2.
Mandatory reading.
This book you
Stream
publicly
control.
purchased on December 18th, 2024 at 9:30 a.m. Is that right?
That's right.
And this book is called After the Affair, the 3rd edition, correct?
Yes.
And then on the same day, you purchased the third book, correct? We'll go to page 3. This one you bought on December 18th, 2024 at 11:48 a.m., correct?
Yes.
And this is the one you mentioned in your testimony yesterday, How to Help Your Spouse Heal from Your Affair, correct?
That's correct. There was two books with the same title actually that we both listened to.
Got it. So there's actually a second book with the exact same title, right?
That's correct.
Okay, and that book's on page 4 of this exhibit, correct?
That's it. Yep.
Okay, and you purchased these on the same day, although you purchased the second one later in the afternoon at around 2 p.m., correct?
Yes, that's what it looks like. Yep.
2 books with exactly the same name, right?
Yes.
That could get confusing if you want to talk about them, right?
Yes.
I'll take the exhibit down. This book, How to Help Your Spouse Heal from Your Affair. That's directed at the wayward partner, correct?
Yes.
It's directions on the cheating person that they have to follow, correct?
Well, I mean, it's to
Yes.
it goes into everything that needs to be done, but and it does it in a way that it explains why those things need to be done. So it was very helpful for me to read as well, because I understood all that needed to be done to kind of fix the relationship. And it does talk about some things that the other spouse has to do as well. But it's primarily focused on what the cheating spouse has to do.
Yeah.
So in your mind, this book is primarily geared towards Ariel, but you just wanted to read it too, correct?
No, like I said, the book describes very well what needs to happen after an affair, and the vast majority of what needs to be done in the initial stages is by the cheating spouse, but it does go into what the other person has to do, and it's geared for both partners. The title is How to Help Your Spouse Heal from the Affair, but the contents of the book is for both parties.
And this book is where you got these terms or these things you told us yesterday that you believed Ariel needed to do, correct?
This is one of the books that I used. Yeah.
This is where you, I guess you had the idea that she should quit her job before you read this book, right?
That's right.
Okay. But this book supported that idea for you, correct?
Yes, absolutely.
And this book, again, as you just talked about, is the one that got that idea that the cheating spouse needs to put in work, right?
I'm sorry, can you ask that again?
This book also helped you with that idea that the cheating spouse needs to put in work. Is that right?
Yes.
And this is, again, the book that supports your idea that the cheating spouse needs to give up their privacy, right?
Proactively give up privacy as part of the healing process for a period of time. Yes.
We're moving forward a couple days, so now would be a good time for recess.
Ladies and gentlemen, let's take a 10-minute recess. Come back at 11:40. We'll go until 12:30. All right.
All right. Not hearing from John in the courtroom there. So apparently he's not allowed to use his cell phone there. Otherwise, I think he'd be jumping on there. I'm not seeing any responses, comments from him. So yeah, this is a good methodical takedown of this defendant, showing all the degree of control, and basically he's just trying to beat her down, beat his wife down, make her feel guilty, rubbing it in her face kind of thing, constantly watching over her shoulder, seeing how she's acting, and she's on pins and needles. So it's just not a good way to try to restore a relationship. So I think the amount of control he exerted probably made sure that they could not continue on a relationship, because all his amount of control would have been front and center. And so even going to a counter and stuff like that with his degree of control, I think it was something that he realized she's slipping away and he's not able to control her. So rather than lose all of the assets that he's acquired in their marriage, having a split custody and all that kind of stuff. And so that's why it looks like this push off a cliff was an easier option. That's the prosecution's theory. So we'll see what we have here for other defense witnesses. Normally you have the defendant testify last. So not sure if they would do that differently here. This attorney's not very experienced in criminal law from what I understand. So, but normally you put your defendant on last. I've had many clients testify as criminal defendants, and it's worked out good. But they also had better testimony than this guy. This guy was not very good on the witness stand yesterday. And and today they still got more to go. So this could go on a while longer. I think he said they're almost getting close to the end here, but I think they need to go over the walk on the trail and all that interaction they had on the edge of that cliff. Yeah, they need to ask about the insurance policy that he was working on acquiring. I think even that was suspiciously covert, where he's trying to look like, oh, I'm getting 1.25 million insurance on me, but only $250,000 of coverage on Ariel. So obviously, I wasn't planning on killing her. Otherwise, I would have had it the other way around. So I think he's very sneaky that way. And why also didn't he give Ariel any information about this trail ride, this park, the fact there's a steep cliff there that can be dangerous? And you're asking, can I talk about how I feel about the appeals for Charlie Adelson and Alec Murdo? For Charlie Adelson, I think that eventually there's a good chance it'll get overturned based on the conflict of interest with the attorney Rashbaum. I would be surprised if it doesn't. And then as for Alec Murdo, I think it may have to go to federal court before they overturn that. Florida courts, I'm just not too trusting of them. But I think ultimately the case with Alec Murdo, I think that's going to be overturned. The actions of the clerk of court there were extremely, I think, troubling to see from this justice standpoint. And from the questions of the jurors, excuse me, not the jurors, the justices there at the Supreme Court of South Carolina, I think that they too will throw out the conviction for the murder, but he's not going to get out because he's got other convictions holding him in there. But yeah, the way some people just insert themselves into the criminal law arena and mess it up, whether it's a juror or a witness or something the attorney does, stay on a case when you know you shouldn't because you got a conflict between multiple clients you're representing. You know, saying your client, testifying clients probably don't have a son and two nurses as witnesses to contradict them. Yeah, that's true. Yeah, his whole story is just so bizarre. It's just not credible. Yeah, and I saw there was someone with a doctor to their title. They talked about him having that travel bag, that mobile bag with syringes in there and certain medications like Proprol. I don't understand why that would be allowed. That was a comment. How would he be allowed to walk in out of the hospital with that? Why would you use a syringe that's been outside of the hospital? You put it in a bag like that, and you keep that bag in your car, in your home. It's just not a sanitary place. All this stuff's supposed to be sanitary, so it just sounds really bizarre. Did his business partners know he was doing that? Becky, you're saying, I think the prosecutor's way off. I've never heard of an emotional affair. How many of you would tolerate your spouse having an emotional affair? You wouldn't. Okay, well, emotional connections with someone not your spouse is very troubling indeed. So I don't know why you're saying you haven't heard of an emotional affair. So it means it never turned physical, but so I think the prosecutor is doing the right thing. This guy was very jealous and controlling. It's just if it was a physical relationship between them, the fact that it wasn't, should he actually be concerned about it? Of course he should be. Nobody's, I think, saying he shouldn't do that. Have concern about that. But when you're going to these levels of control and spying on your mate, it's just not. You got to have some trust. If you just never have any trust for your mate after there's any kind of cheating going on, then I think it can be very harmful and it can make the relationship be destroyed just from the fact that you're never able to build trust and there's constant spying going on. Okay, here's someone that says, my husband is an anesthesiologist and never had a bag like that, kept everything in the hospital. I would think that would be the requirements of his profession. Prime time KCL. I wonder if Gerhardt dug a hole and buried that syringe in the vial of meds during the 8 hours or so he was in hiding. Could very well be. Yeah, why would they have propofol outside of the hospital? Says Mortal Clown. Yeah, if he was trying to give her the Michael Jackson drug so she'd get knocked out within seconds or minutes, then she couldn't resist being thrown off the cliff. Is that what the prosecution's going to argue? Him taking off for hours on end, wandering around, thinking about killing himself. No, he knew he's going to go down. He did admit that he thought everything's over for him. His career's over. Because she's making that up. Why wouldn't you just get out your phone and start videotaping your wife acting crazy as he was trying to describe it? Okay, this is way too long of a sidebar. The jury's still sitting there. All right, here we finally starting up again. Yeah, I wonder if they did any kind of search for the phone. Her phone. So she never got her phone back. That's really incriminating, I think. GS Dogsmile, you're saying the syringes are sealed, they remain sterile till open. Yeah, but they're in a when you handle the package, you're going to have terms on your hands by handling it. So there's a problem there, I think.
Dr. König is on the stand and still in their role. All four counsel of record are present. All jurors are
It's morning break. Okay, sorry.
Mr. Garner, can we continue on with the cross-examination?
All right, Dr. König, the last question I asked you was about December 18th. Now I'm going to move forward a couple days to December 21. Okay?
Okay.
On December 21, I'm going to publish December 21, 2024 at 2:49 p.m. You opened a PDF file on your computer that was a November 2022 retirement account statement for Ariel. Is that right?
I don't recall doing that specifically, but that sounds like something I would do. Yes.
That sounds like something you would do, is what you just said?
Yes.
And as of November 2022, Ariel had a retirement account, correct?
Yes.
And that retirement account, again, as of 2022, was valued at $191,439, correct?
I don't remember that exact number, but that sounds about right.
Was that number
Is this
accurate?
Yeah. Yes.
And in November 2022, you were the primary beneficiary of that account, correct?
That's correct.
That means that if anything happened to Ariel, you would get that money, right?
Yes.
I'm going to publish States Exhibit 125, page 7, or page 3. This is the metadata for the account that you accessed on, or for the document you accessed on December 21st, 2024. Is that correct?
Yes.
All right, and this is the Westinghouse November 2022 statement, correct?
Yes.
And this is the first page of the statement, correct?
Yes.
Okay. And in the top right, it says total value of the account, $191,439, correct?
That's correct.
Okay, take that down.
He's gone over these documents with his attorney, so saying, I don't recall. And then later on, when
December 24th, 2024, at 3:36 a.m., you accessed a document from 2018 on your computer, correct?
I don't recall that.
yeah, you do, because you went over it with your attorneys. That's what I'd be
Published States
asking them.
125 at
You
page
didn't
7.
prepare to go over all these documents?
On December 24th, 2024 at 3:36 a.m., you accessed a PDF, correct?
I have no recollection of accessing this. This is a document that talks about,
Objection, non-responsive.
Sustained.
Okay. Now, the last access date and time from this metadata is December 24th, 2024 at 3:36 a.m. Correct, Doctor?
yes,
Okay. And the file is located in a folder called pit or Dropbox/RE/pit tuition benefits, correct?
that's correct.
And the specific document discusses the tuition that paid for Ariel's master's degree, correct?
I don't, that's part of it. I mean, until I see the document, I can't tell exactly what it is, but I think it talks about, because I was,
Go to page 8.
Well, can you let him finish? Go ahead.
I was an employee of University of Pittsburgh, and through that, we got some benefits that helped pay for her MBA that she was doing at University of Pittsburgh.
So that's just what I asked, right?
Well, is there a question? What's the next question?
That is the question. Is that what I just asked?
Can you remind me what you just asked?
I asked if the document was about how the education benefits from Pittsburgh that paid for Ariel's graduate degree.
Yes, that's correct.
Okay. Now I actually have the document on the screen, right?
Yes,
And your benefits from working at Pittsburgh, at the University of Pittsburgh, paid for Ariel's education, correct?
not completely. It defrayed some of the costs.
And this document is how you started that process to get parts of her master's degree paid for, correct?
Yes, that's the application form, I believe.
The title of this document is Request for Education Benefits Form for a Spouse/Domestic Partner, correct?
Yes,
Okay. And again, you were looking at this document at 3:36 a.m. on December 24th, correct?
I have no recollection of looking at this document in December. I don't know why I would be doing it at 3:36 a.m.
Okay. And December 24th, obviously Christmas Eve, correct?
Christmas Eve, like Christmas Eve morning.
It's the middle of the night.
Middle of the night, right?
Yes, right?
Yes.
3:36 a.m. and you have no idea why you would be looking at this document, right?
No.
You have no idea why you would be looking up the benefits that Ariel got from your job, right?
Right.
Hey, just think
On
about
December 24th, 2024, at 3:36 in the morning, you were upset about this emotional affair, correct?
No,
You were
no.
I was
thinking,
probably sleeping.
that you
You're
paid for
thinking
Ariel's
divorce.
education,
What's it going to cost
and this
them?
is how she repays you, right?
No.
Mm-hmm. Yep. Great point.
So your testimony today is that you were not thinking that.
Yes.
He
Your
was
testimony today is
fuming.
you have no idea why you were looking at these benefits, right?
Yeah, I don't remember looking at this, and I don't remember the reason, if I did.
Okay. Yeah, right.
And you testified you have no idea why you would have looked at it in the first place. Is that right?
Not at this time, no.
All right, we're going to publish States Exhibit 105. I'll make sure we start at page 1. All right, publishing States 105 at page 1. This exhibit is your Reddit internet history, correct, Dr. König?
Yes.
This is from December 24th, 2024 at 4:34 a.m., correct?
Yes.
And you're
Christmas
looking at a
morning.
website or a webpage titled Lying Again. Isn't that right?
Yeah, that sounds possible.
This is less than an hour after you're looking at those education benefits. Isn't that right?
It's an hour after the timestamp, but I
How
don't
dare her,
recall looking at
Victoria.
that tuition benefit. But I do recall being on Reddit in December. I can't remember exactly when and where. But maybe I was up at 4:30. That sounds plausible.
That sounds plausible.
Yes.
All right. Later that day, so we're still on Christmas Eve at 12:49 p.m. You emailed yourself 3 separate files, correct?
I don't recall.
12:49 p.m. Christmas Eve, you emailed yourself 3 files all related to Jeff Miller. Isn't that right?
I don't recall.
Published dates 119.
You'd have gone
first
over this
page.
with your attorney preparing for trial in your testimony, especially if you're going to testify.
On December 24th, 2024 at 12:26 p.m., you sent an email from your gkoenig@proinbox.com email to the same email address with an attachment called WhatsApp chat jeffmiller.zip, correct?
Yes.
And then we're going to publish states 120, the first page, the metadata. At 12:20 p.m. on the same day, Christmas Eve, you sent yourself WhatsApp chat jeffmiller2.zip, correct?
That's correct.
And states 121 with the metadata page, the first page. On the same date, December 24th, 2024 at 12:20 p.m., you sent a third email to yourself, right?
That's correct.
And this was with WhatsApp chat jeffmiller3.zip. Is that right?
Yes.
So going through our timeline on Christmas Eve, 3:36 in the morning, document about Ariel's financial benefits from your job, correct? That's what's being opened on your computer.
Yes.
4:34 a.m., you start your Reddit search about lying again, correct?
I don't know if I started it but yeah, I was looking at that thread at 4:34 p.m.
12:20 p.m., you send yourself these emails, correct?
Yes.
It's safe to say that on December 24th, 2024, you were thinking about this affair, correct?
Yes.
You were upset about this affair, correct?
No.
I was hurt and confused and a lot of things.
Fuming mad. Angry.
And I was probably upset too. Yes.
Yeah. Angry.
We'll move on to Christmas, Dr. König. We're going to publish now States Exhibit 105 at page 6. Okay, now it's on the screen. At 3:23 a.m. on December 25th, 2024, you go back to that Reddit website, correct?
Yes.
This is Christmas now, right?
Yes.
Christmas Day, 3:23 a.m. You're on Reddit, right?
Yes.
And you look at Reddit around that time, 3:30 a.m. for a couple different posts, right?
I don't remember, but that sounds plausible. Yeah.
And then later in the day, the afternoon now at 2:16 p.m., you go back and look at another Reddit post on the same subreddit, correct?
I don't recall the exact date and time, but that sounds plausible. Yes.
On December 25th, 2024 at 2:19 p.m., you went to a Reddit page with a post titled, "Can't have physical relationship with WP anymore." Isn't that correct?
I don't recall, but it sounds plausible.
He's not admitting to any of this. This sounds plausible. He's so prepared for his
We're gonna
testimony, he
publish
would
dates
know that.
105, page number 20. This is that page you visited at 2:19 p.m. on Christmas, correct?
Yes.
And the title of that page is "Can't Have Physical Relationship with WP Anymore," correct?
Yes.
WP is wayward partner. Is that right?
Yes.
And in your relationship, in your mind, the wayward partner is Ariel. Is
That's
that right?
correct.
So you're thinking about the physical relationship at this time, correct?
That's one of the things, yeah, that I was thinking about and reading about.
Just a few minutes later, you search a term on Reddit called Darvo, correct?
I don't recall when I did that, but I do recall
Closing
searching
his
for that
eyes.
term. Yes.
Sign of deception.
We'll publish 105 at page 24. This is that search, isn't that right, Doctor?
Yes,
Okay. And this is not a specific post about the word Darvo. This is actually a search for information about the word Darvo, correct?
that's correct.
And you know what that acronym means, right?
Yes,
The D stands for deny, right?
yes,
The A stands for attack, correct?
yes,
And the RVO are all connected together and they mean reverse, victim, and offender. Is that right?
that's right.
So in order to use that strategy first, the accused will deny the accusation, correct?
I disagree, Lynn.
Oh, I'm sorry, can you ask that in a different way or clarify?
The first step under the D in deny means the accused will deny the accusation, correct?
I mean, Darvo refers to a thing that,
Objection, non-responsive.
He's answering the question.
Objection sustained.
can you ask the question one more time?
The D in Darvo,
Stands for deny.
and the first step is, or that means that the person accused will deny the accusation, correct?
That's correct,
The A stands for attack, right?
right?
And that step is the person accused will attack the accuser's credibility. Is that right?
It stands for attacking the accuser in many different ways, not just their credibility. But that's one of the ways in which they could be attacked. Yes,
So you can attack credibility, right?
yes,
You can attack them in other ways, correct?
that's right.
You can attack them with irrelevant information, right?
Lots of different things.
Lots of different ways you can do the attack, right?
That's correct.
And the last section of Darvo, the RVO, again stands for reverse, victim, and offender.
Right. Yes.
And that's when the perpetrator portrays themselves as the victim, correct?
That's right.
Darvo is a tactic used by individuals or institutions to deflect blame and responsibility for harmful actions, correct?
Yes.
We're going to move on to the next day, Doctor. December 26, 2024, at 6:47 a.m., you reviewed your 2018 tax notes. Is that correct?
I don't recall that specifically, but that sounds plausible.
I'm going to publish the metadata page, so the first page of States Exhibit 114.
Everything he's been working for
Okay. Can you look
financially
at the screen, Doctor?
can implode
Yes.
if he
December
divorces.
26, 2024,
That makes
at
them even madder.
6:47 a.m., you accessed a document called 2018 Taxes GK Notes,
Yes.
correct? This document is your notes about the taxes you paid in 2018, correct?
It's the document that I create that has all the information that I give to our accountant so that to help them do our taxes. So I make a document every year, and for the next year, I copy and paste the previous year's document, and then I just change the information and send it to them. Yes. So it does have how much we paid in taxes, but it also has a bunch of other stuff in there.
And you said then for the next year, each year, you'll copy and paste the last year because obviously you just want to use the most recent year, correct?
That's right.
But the day after Christmas, you're looking at your notes from 2018, correct?
Seems so. Yes.
And in those notes, you discuss or you have the information how much child support you paid in 2018, correct?
That's correct.
You have how much alimony you paid in 2018, correct?
That's correct.
You paid about $29,000 a year in child support in 2018, correct?
That's right.
You paid about $6,000 in alimony in 2018, correct?
That's correct.
And this was to your ex-wife, Jessica Patella-Ray. Is that right?
That's right.
Dr. König, this is 2018 money we're talking about, right?
Yes.
Inflation has clearly gone crazy since 2018, right?
That's right.
So in 2024 dollars, that'd be quite a lot more, right?
It would be more. I'm not sure how much more. And actually, I don't know. Child support is a calculation, so I'm not sure if But yeah, I'm sure they make adjustments for inflation.
How much money were you making in 2018 again?
Probably 350,000.
So you were making less money than you made in 2024, correct?
State's proven their case.
About the same, actually. I took a significant pay cut when I moved to Maui.
Dr. Koenig, isn't it true that these tax notes that you have say you actually made $446,000 in 2018?
If whatever's on the tax notes is accurate, so if I said 350, then I misspoke.
Okay.
What was the final number?
I'll publish the exhibit now, and this is page 2 of the exhibit. Okay. So you made $446,000 in 2018, correct?
That's correct.
Okay. While we're talking about December 26th, I do need to follow up, Dr. Koenig, because you mentioned that you had a big fight with Ariel on that day, correct?
That's correct.
The same day you're looking up your tax documents with your alimony and child support, you get into a fight with Ariel. Is that right?
The same day that I look at the tax documents that has a lot of information on it, including the alimony and child support, I get into a fight with Ariel. That's correct.
And given the fact that you looked at these tax documents at 6:47 a.m., the fight was after that, correct?
Yes.
The fight was during the daytime, correct?
It was at night.
So the night of December 26th, you get into this fight with Ariel, correct?
That's correct.
And this is the second time in this fight that you tell Ariel to move out, right?
It's the second time that I ask her to move out if she doesn't take accountability for the affair. That's correct.
It's the second time that you ask Ariel to leave her 18-month-old, right?
That's correct.
It's the second time that you ask her to leave her 4-year-old, right?
Well, that's not correct. I wasn't asking her to leave the children. She would move 200 yards down the street to her parents' house and see the children as often as she wanted to, but she would not be physically living in our house anymore. So that is not correct. I did not ask her to leave the children.
So you have this fight with Ariel on the night of December 26th, correct?
Yes.
And then on the morning of December 27th at 6:34 a.m., you look at Ariel's pay stub again, correct?
I don't recall that specifically, but it's the end of the year. I was probably looking at a bunch of tax documents and financial things. And I always get up early because I have to get up early for work. So that sounds very plausible.
It was the end of the year and you wanted to look at tax documents. Is that what you just said?
That's all I can think of why I was looking at these documents then is end of year finances.
So it's 2024, right?
Yes,
The end of 2024, you want to start preparing your taxes for the year, right?
that's correct.
And you decide that the best way to prepare for your taxes of the year 2024, we're going to publish dates 125 at page 10. The best way to prepare for your taxes in 2024 is to look at how much money Ariel made in the month of January 2022.
I'm sorry, but what's the question?
This document has nothing to do with how much money you'd pay in taxes in 2024, correct?
That's correct.
The same date, December 27th, 2024, you order a hidden voice recorder, correct?
That's right.
So the day after your fight with Ariel, right?
And the morning, and we were fighting that morning as well. So the same day.
You fought in the morning of the 27th as well?
That's right.
The same day that happens, you buy this hidden voice recorder, correct?
That's right.
You buy it from Walmart.com, right?
Yes.
And the device was advertised as a, quote, hidden voice recorder, correct?
Yes.
It was also advertised as a spy device, right?
Yes.
The recorder had a magnet on the back, correct?
Yes.
And that magnet made it so it'd be easier to hide, right?
Magnet made it so you can attach it to magnetic objects.
You could put it underneath the desk if the desk was metal, right?
You could do that.
You could put it behind a fridge if you wanted to, right?
If it's the right metal, yes.
And you testified yesterday that your purpose with this device was to secretly record Ariel, correct?
That's correct.
This device would also work just as well to leave in her home office. Isn't that correct?
You could, yeah, you could leave it. I mean, you can leave it wherever you want to leave it.
You could leave it in her home office to test out whether she was still talking to Jeff Miller, correct?
You could.
On the same day, December 27th at 9:15 a.m., you looked into the WhatsApp login portal on your laptop. Is that right?
I'm sorry. Can what time did you say?
9:15 a.m. You logged into the WhatsApp login portal from your laptop, correct?
That sounds plausible. Yes.
So as you're having this fight with Ariel in the morning, 9:15 around then, you log into WhatsApp, right?
Yes.
You want to find out who she's been talking to, what she's been saying, right?
No. I was logging into my WhatsApp.
You want to
At
find
that
out
point in
if Ariel's
time,
still. Sorry.
You remember
at that point in
that?
time, I was
Really?
not logged into her WhatsApp on my computer any longer, and I was using WhatsApp for my work, and I was logging into my WhatsApp.
So your testimony is that immediately after having this fight, after same day you're ordering this recorder to spy on Ariel, that you're logging into WhatsApp for other purposes.
Yes.
And on December 27, 2024, you order another audiobook. Is that correct?
I don't recall.
You order an audiobook called Getting the Love You Want, right?
Oh yes, I do. Yes.
Let's walk us through December 27th again, Doctor. In the morning, 6:47 a.m. Sorry, let me get the time correct. In the morning at 6:34 a.m., you look at Ariel's January 2022 pay stub, correct?
Asked and answered. Going through it again, you just went through it.
Yes.
Yes. Is that the answer to my question?
I'm sorry. Can you ask the question again?
Okay, we're going to review December 27th, 2024, okay? So 6:34 a.m., you look at Ariel's old tax document. Or her
Asked
old-
and answered, Your Honor. Just went through this.
He didn't answer.
I mean, about 8 minutes ago, we went through this.
Please answer no.
Yes.
You looked at her, or you also got into a fight with her that morning.
We continued an argument from the previous night.
Same day you order the hidden voice recorder.
Yes.
Same day you log into WhatsApp.
Yes.
Asked and answered.
And same day you order this next audiobook, correct?
Yes.
Moving on now to December 29th, 2024. You looked up your wife's Facebook profile, correct?
Excuse me. I don't recall that specifically, but I probably did.
And you specifically went to her friends list, isn't that right?
Again, I don't recall that specifically, but
Of course
I
he
probably did.
does. Jury doesn't believe in this. All this stuff he doesn't remember, but it sounds plausible or probable or whatever he's saying.
Now,
No, it's
on
darn right.
December 30th, 2024, we're moving closer to New Year's, right?
Yes.
And on December 30th, 2024, you searched LinkedIn again for Andrea Miller, correct?
I don't recall doing that
You don't
on a
recall?
specific day, but I do recall looking her up again later in December.
We'll publish Dates Exhibit 109 at page 4. You looked up Andrea Miller on LinkedIn on December 30th, 2024 at 6:49 a.m., correct?
Yes. I looked at her contact info.
She still hadn't replied to your email, right?
That's right.
She never called Ari to yell at her, right?
She never called Ari to do anything, as far as I know, actually. She might have to tell me, but as far as I know, Andrea never called Ari.
And then after searching for Andrea on LinkedIn this morning, you canceled your LinkedIn Sales Navigator Core account, correct?
That sounds right. I had to cancel it within 30 days. And so I probably went in LinkedIn to cancel the account and then also clicked on Andrea's profile.
This is page 5. this is the email confirming your cancellation, correct?
Yes,
So, and this is at 6:56 a.m. Is that right?
that's right.
Okay, so you look up her email and then you cancel. You look up her account and then you cancel, correct?
Yes,
And you say you cancel because you didn't want to pay the fee. Is that right?
that's right. The only reason I signed up for that feature of the LinkedIn account was to be able to get Andrea Miller's contact info.
If you hadn't canceled it, it's in the realm of somewhere about $100 a month. Is that right?
It's expensive.
So you got what you wanted, so you were done.
That's right.
And on that same day, December 30th, you also purchased a new audiobook. Is that right?
I don't recall.
You purchased an audiobook called Not Just Friends on December 30th, 2024. Is that right?
I do recall purchasing that book. I'm not sure of the exact date, but
He's
that
really obsessed
sounds
over
like
this,
the right
isn't
time
he?
frame, yes.
And then on the same day, December 30th at 7:29 p.m., you open up a spreadsheet on your computer, correct?
Probably. I work with spreadsheets very, very frequently.
On that date at 7:29 p.m., you opened a spreadsheet about your and Ariel's wedding. Is that right?
I don't recall, but that sounds plausible, yes.
Lulu,
And in that spreadsheet,
trust
There
me, you're not
was-
correct.
information
Jury.
about the wedding, correct?
There's a lot of information in the spreadsheet.
There's a guest list, right?
Guest list,
There was
Yes.
Tasks for you and Ariel to do to prepare, correct?
yes,
And there was the cost.
and a lot of other stuff.
There was the cost there, correct?
The cost was there too, yes.
Okay. Sorry. Moving on now to December 31st. December 31st is Christmas Eve, right? I'm sorry, New Year's Eve.
Yes,
Okay, New Year's Eve, 8:38 p.m., you accessed a PDF file on your computer from that JPR divorce folder. Is that correct?
I don't recall doing that at all.
You don't recall?
No.
We'll go to States 113. We'll publish page 2. So, on December 31st, 2024, you can see the exhibit, right, Doctor?
Yeah,
On December 31st, 2024, at 8:38 p.m., on your computer, this document was opened up, correct?
again, I don't recall opening up this document. I can't think of a reason why I would have opened up this document. Again, it's a credit card statement from 2016 that was part of the hearing on the divorce, but it's not even actually it's not even the document for the divorce hearing. It's just one of the credit card statements. And I have no recollection of opening this document at that time and don't know why I did that. Or if I did it. And that's what I'm saying, because it says file system last access. Like, so does that get triggered when something other than just opening the document happens? Because I don't recall opening up this document at all.
You said
At-
a lot
at
of
that
words there,
time.
but at the end of the day, you don't recall, correct?
That's correct. That's
Okay.
correct.
This document is in that same folder we talked about earlier, correct?
Yes,
This is supportive documents for your 2016 divorce hearing,
that's
correct?
correct.
And these are the kind of documents that you want to have to present in the hearing, correct?
That's correct.
They're financial documents that are relevant to a divorce, right?
That's right.
And this one's actually a bank statement about not yourself, correct?
It's a bank statement that was a credit card that was actually in my father's name during that time period. But we were. I'm trying to recall exactly. I think we had used it to transfer like a credit card balance that we had onto his credit card, because they were offering like a no interest, no payments for whatever, and we were using that to pay off this credit card. I was using it to pay off my credit card debt at a more favorable or zero interest rate. But yeah, that was a credit card in my dad's name.
So you included this document in your divorce hearing folder because it was relevant to your divorce, right?
That's correct.
Now, at 8:38 p.m. on New Year's Eve, you also looked up a March 2022 pay stub for Ariel Koenig, correct?
I'm sorry. Can you say that again?
At 8:38 p.m., the same time, on December 31st, 2024, the same date, you also looked up a March 2022 pay stub for Ariel Koenig. Is that right?
I don't recall doing that specifically, but that sounds possible. Yes.
We're going to publish dates 1, 2, 5, page 11. All right. Dr. Koenig, this is the metadata for that document, correct?
Yes, this is the data for that document. Yes.
Okay. And the last access date and time is December 31st, 2024 at 8:38 p.m., correct?
That's correct.
Why they don't show the PDF?
And this document is not in the taxes folder, is that right?
Right, which is, it just makes no sense that I access this document out of that folder.
Dr. Koenig, that's not the question.
Yes. What was the question?
This document is not in the taxes folder,
That's
correct?
correct.
Okay. And again, there's no real reason to be accessing this document, correct?
There's no reason that I can think of accessing this document out of that folder. I can think of a reason why I was looking at her taxes potentially at the end of the year, but I don't know why I would have.
The financial pain.
I would have never gone to that folder to look for her tax documents because I have a tax document folder that has all of her tax stuff in it.
And again, the document we're talking about is literally just a pay stub for 1 month, right?
That's right.
It's, well, the only information in that document is how much Ariel got paid in March 2022, right?
Right.
No relevance to taxes in the year 2024, correct?
That's right.
She's not even at the same job at this point, right?
That's right.
Finances were
So at the same
disgusting.
time, the data from your computer shows opening up divorce-related documents as well as an old pay stub for Ariel, correct?
That's correct.
he was ruminating over how much he was going to
each
lose
person gets
with a
paid is
divorce.
very relevant in divorce, right, Dr. Koenig?
That's correct.
And again, this is all 8:38 p.m. on New Year's Eve, right?
That's correct.
Now, January 3rd, 2025, moving forward a couple days, you save a file on your computer with an Excel spreadsheet that has the chats between Ariel Koenig and Jeff Miller. Is that right?
I don't remember the exact date and time, but I did have a spreadsheet like that. Yes.
You had a spreadsheet that was essentially the entire chats that they had, correct?
Yes.
And you saved that in January 2025, correct?
I don't remember the exact date. I thought I did that in December. I know I created the file in December.
Okay, we'll publish dates 139, and you created the file on December 24th, 2024, correct?
That sounds more reasonable.
Okay. You accessed the file on January 3rd, 2025, correct?
It looks like it, yes.
So it's safe to say that on January 3rd, you're still thinking about these messages, right?
Oh, absolutely.
They're still in your mind a lot, right?
Definitely.
You're still upset?
I'm still thinking about the affair.
It's hard to get off your mind, right?
I'm still thinking about the affair.
You're
Yeah.
thinking about it a lot, right?
Yeah,
I'm
good.
thinking about it often, yes.
All the
It's
time.
hard to stop thinking about it, isn't it?
No, at that point in time, I could stop thinking about it and I was functioning just fine.
That doesn't
So
sound
you say
right.
that in January 2025, you were okay to stop thinking about it when you needed to, right?
Absolutely.
On January 7th, 2025, you purchased another audiobook, correct?
I don't recall.
We'll put States Exhibit 106 up on the screen. And this is going to be
His
page
attorneys
6
would have
of
showed
7.
him that.
On January 7th, 2025, you purchased an audiobook called Not Just Friends, correct?
we said that I purchased that on the 30th.
January 7th, 2025. You purchased this audiobook, correct?
Yes.
And on January 7th, 2025, again, the title was not, and it's getting little half quotes, Just Friends, right?
Isn't that the same book that we said I purchased on the 30th?
Shows how good his memory is.
Dr. Koenig, you weren't asked about any books on the 30th of December,
Okay.
were you?
I'm sorry. We've been talking about a lot of books and a lot of dates, but
Is there one they
I
missed?
agree. I purchased that book on the 7th.
Okay. So you agree you purchased this book on January 7th, 2025, correct?
Yes.
And obviously, when you purchased this book, you were still thinking about the affair, right?
Yes.
It was still on your mind, right?
Yes.
And you actually purchased this book, I'll zoom in on the email time, at 4:32 a.m., correct?
Yes.
So at 4:32 a.m., January 7th, you're still thinking about this, right?
Yes.
The same day, January 7th, 2025, at 6:59 a.m., you go back into your JPR, Jesse Patella Ray divorce folder, correct?
I have no recollection of going into the divorce folders from my previous divorce during this time.
Again, no recollection.
No recollection.
We're going to publish dates 113 at page 3. Can you take a look at that?
Yes.
All right. So this is a file name 2012 or 2012 412 Ghent plane ticks, correct?
Yes.
The document we're talking about is a plane ticket to go to the city of Ghent in Belgium, correct?
Yes.
And that's a trip that you and Jesse Patella Ray took together, right?
Yes.
And as the metadata shows, the last access date and time, January 7th, 2025 at 6:59 a.m., correct?
Yes.
This one is not in the supportive documents folder, though, is it correct? Is it?
No, it's in the same hearing folder, but it's a folder called Jesse Lived Extravagant Life.
Oh,
Jesse being the woman you were divorcing at the time, correct?
Yes.
You made a folder called Jesse Lived an Extravagant Life, right?
That's correct.
He's mad about it. He paid for all that.
You were a little bitter at the time you made this, right?
It's going to happen twice now. If she's alive.
I was feeling a lot of emotions, I guess. I was mostly happy that I was getting divorced. At that time, we had, separated, and we were both at that time. She was ready to get remarried, actually,
And this
and
folder-
I was moving on, and I wasn't really feeling better. But the folder name is descriptive of what's in it, not of my feelings at the time, I guess I would say.
You made the name on the folder, right?
Yes,
And you say it's descriptive of the documents inside, correct?
that's correct.
So that means the documents inside are your evidence of how extravagant your ex-wife's life was, correct?
That's correct.
Dr. Koenig, isn't it true that this trip in 2012 to Ghent, you went with Ms. Patella Ray?
Yes,
You guys went on that trip together, right?
yes,
And it's in the Jesse Lived Extravagant Life folder, correct?
yes.
Before I move on to the next date, do you want to take the break or no?
Of course. You can go up to 12:30 if you just want to like to take the break, unless we should take it now.
The next group has quite a lot.
We'll take our break now. So, Barner, ladies and gentlemen, we'll come back at 1:30. We'll continue on. Leave your notebooks on the chair. We'll talk to everybody about this case. Keep an open mind. Do not try to learn about this case outside. Have a good night. All right.
Okay, this is live. They're going on break at 1:30 Hawaiian time. So he's not doing good, folks. All these instances, he doesn't remember, doesn't recall, but then he doesn't dispute it. He knows very well this evidence is there in his attorney's folders. He's gone through that. He would have gone through every little detail of the file against him and then talk to his attorneys about all of that. Okay. So for him to say, I don't remember that. Oh, yeah, I don't remember exact date and time. Okay. That is really the prosecutor holding him to that date and time. He should just say, yeah, that sounds right. That sounds right. I don't recall the exact, but yeah, that sounds right. That sounds right. I'm familiar with that. Sure. You're familiar with all this. So he's just not coming across as very credible. And so I think that this methodical breakdown of all the stuff he was searching and looking at and trying to save and hold against his wife, and then he's having flashbacks of what this is the same kind of thing happened to me before, and she's living a life of wealth and glamour and all this, and now I got to go through this again, and then now I got more kids to have to take care of. If I owe any child support, so he's just going over and over in his mind, just getting madder by the day. I would submit that's what it's looking like to the jury here. So someone's saying here that they thought he's doing well. I can assure you he's not doing well with the jury that's sitting there in that room. They're on lunch break right now. Let me see. Let me see if I can get John on the phone. I sent a text message. So let's see what the jury is thinking about this testimony based on the mannerisms. Are they looking at him when he's testifying? Is there any emotions that we can pick up on the jury? All right, big mistake putting him on the stand. The reason they have to put him on the stand is because they had such a good case against him, and he's hoping that he can claim self-defense. You can't get a self-defense instruction unless you present evidence of self-defense. So there's no other testimony order of self-defense. It's just him that needs to testify that because there's no other witnesses. There's nothing on videotape to see. Stand by. Just sent John a link. No, he's not out on bail. So he's been in confinement this whole time since he got arrested. Yes, John is there at the courthouse watching this. Yeah. We have Joel here saying, I see right through this sicko knowing was he trying to mend the relationship at any point, arranged everything ahead of time to get rid of her and look innocent. And when he's looking through all that financial stuff, he realizes divorce times 2 and losing so much that he did the last time is not something he wants to live through again. So he wasn't in the condition or mindset that he wanted to kill himself at any point, do I believe. It was all part of manipulation. So, all right, here we go. John, can you hear us?
Yeah, Carl, just putting in my earpieces here. Can you hear me?
Yes. So tell us, what's is the jury paying attention to this Dr. König? Any reaction you see from the jurors?
This is my second day attending. I have to say they're the same as they've been. So this is day 2 that I've watched. I didn't see last week at all because I wasn't here, but they're all very serious. They're all paying attention. They're all dialed in. I would say very few note takers today. At any given time, maybe one person, but they don't look at us at all, the jury, in the gallery. They're paying attention to him. They're looking a lot between the prosecutor and Dr. König. And I would just say you can ask for a better jury as far as their professionalism when they walk by us. Not a single jury, because when they leave, they have to walk right by us in the gallery, and not a single one of them looks up at us or anything. They're very dialed in, I think, on their job. I would say the youngest person's about 20, 21. Oldest is probably in their 60s. I would say the average age is probably 40. Other jurors, I would say I counted 11 women and 5 men. I think it's 12 and 4. Carl, don't quote me on that.
Yeah.
As far as the alternates, but yeah, they're definitely paying attention, and I think they're picking up on everything that you and I are seeing, and everyone else in the audience is seeing. So
Yeah, what I've been commenting on, apparently you can't hear me when you're in the courtroom, obviously, unless you have an earbud on. But anyway, I'm just thinking, does it sound like he's having selective memory loss on all these things that the prosecutor is bringing up for things he was researching at 3 a.m. on Christmas Eve and all that kind of stuff? What's your take on that, being there live in the courtroom?
my perception, Carl, is that everything that's coming to me on his testimonies is being picked up by them 100%. He's clearly has selective memory. He clearly doesn't like to admit the things that are very incriminating to him. To me, he looks like a liar, Carl. He just looks like he'll agree on the things that, he absolutely can't budge on. But if it's really bad, he will hedge his bet and says he doesn't. So selective memory is a good way of putting it. Yeah, and I think Carl, it's come across to everybody that he's lying up there on the stand, and it looks very bad. I don't know what you think. I like how the prosecutor is he's very methodical, calm. His demeanor is very good.
Right. He's raised his voice too. We can hear him a lot better on the audio. I don't know if you know. Has he picked up his voice level at all in the courtroom since
the audio in the courtroom is very bad. So it's almost like his voice isn't amplified at all to us in the gallery. So you guys probably have a much better audio on him than we do. We don't have the audio in the courtroom. It's not very good.
It wasn't good before, but it's good now on the cross, is what I'm saying. So whatever he's doing, his voice he's projecting his voice better, so we're picking it up better.
And I can tell you why, Carl. It's where the microphone. So there are only 2 microphones in the courtroom. This is probably boring half of you guys, but of course there's one microphone that's up on the witness stand. The other one is actually a wide area mic. It's called a shotgun mic that's placed. It picks up patterns, but not very loudly. So the closer you get to it, so where that mic is, when he moves towards the witness, that's where you pick him up the best, isn't it? Because the microphone is just right off to his right. So that's why it's just the acoustics of the room and based on where that microphone is.
He sounds good all the time from what I've heard today. So
good.
It sounded like he was in a well before, and now it sounds like he's out of the well. So anybody there in the gallery that you know as witnesses, or any of the family members for either Ariel or Gerhardt for that matter?
There is an older couple that's been there both days who Dr. König acknowledges very briefly, though. I don't know if you guys see it on camera, but when he comes in, he looks at them for less than a second, smiles and puts his head down. There are other 2 people in the gallery in that row next to that elderly couple, but I don't think they're attached to him at all because he didn't acknowledge them at all. So as far as family members, that might, if that couple is related to him or friends with him somehow, I would say that's it. Everyone else in the courtroom, except for maybe 3 or 4 people, are media.
Yeah, and Ariel's not going to be there because smart prosecutor, always have her subject to recall, and so that's why I'm sure she's not in there watching. So what about any sense of witnesses? Normally a sharp defense attorney always puts their client on last. Are you hearing anything about witnesses? How many more witnesses they have to present for the defense case in chief?
No idea at all, Carl.
Okay.
No idea. What's your estimate? What do you think?
Well, like I say, it's pretty much unheard of to not have your client go last, because you want your client to testify and clean up any loose ends that you didn't bring out through your other witnesses for the defense. So
right.
if you look at, well, I guess Charlie Adelson's really not a good example because they really didn't have any witnesses other than a couple before him.
Mhm.
But normally, even if, you know,
Mhm.
no matter how many you have, whether you have 1 or 10 or 20, 30, you're always going to have your client go last. So I would expect him to be the last witness here. So they're on a lunch break, and I would say, you know, we still haven't gotten to the actual day in question on what
That's right.
happened on top of that trail and that cliff.
Mhm.
So that can be probably another hour and a half, at least 2 hours or more. It could be 3, 4. I don't know what this prosecutor's up to, but
Mhm.
he's moving along at a good clip. So I don't think he's lost the jury at all. Would you agree with that?
Yeah, I'd agree with you 100%. Um, the jury is paying attention. I would say uh, my take on this jury is very similar to Donna's trial um, last year, as far as there's not somebody. I would say the only person that stands out is somebody that's got purple hair, and that's the youngest one on the jury. But they're not. Everyone's listening, Carl. I'm really impressed. I think they're all dialed into what's going on. They see it for what it is, and my personal intuition tells me that they can't wait to get back in that jury deliberation room.
Yeah, so this you say they're a little bit, when the jurors stop taking notes, that means that they've made up their mind. So if they're busy
Mhm.
taking notes throughout the trial, and then you get the defendant of all people on the witness stand, and they put their pen down, that pretty much seals the deal from my experience. So if they're not really taking much for notes, unless they're looking for something real, you know, if they find something very incriminating, oh yeah, he's lying about this, I want to bring this up back, then they can write something like that down. But if they're not busy taking notes, that's a real good sign the prosecution.
The one time today that I noticed a lot of them taking notes was when it was divulged how much money he made, where he estimated 350 and it came back to 460. Do you remember that part recently? A lot of note takers for that. I'm not sure why. Do you?
I think it comes down to, you know, he knows so much about things that he's testifying to, but on cross-examination, he can't recall what he was
Mhm.
making a certain time of year. This guy seems like he has impeccable memory on anything financial in his life.
Yeah.
And he's ruminating over the fact that he lost so much in his first divorce.
Mhm.
And that's why we heard that file folder name. I forget, the extravagant life, or however that was worded,
Mhm.
for his first wife. And now for the second wife, he's thinking this is a repeat do-over where he's going to be basically raked over the coals financially a second time. So I think that's what the prosecutor is doing a good job of. This is going to be their argument in closing, which is like, he wasn't going to let this happen to him twice. He'd already lost his shirt in the first divorce. He was able to, you know, get ahead in life and be there in a nice home, and she was going to throw it all away, and then he was going to owe her more than half probably when it's all said and done. And so he's the one that helped put her through school, through his university family tuition reimbursement kind of thing. So I think he's looking at her as the way it's coming across, and it's looking at like the jury is going to pick up on this, that he was thinking, oh, you know, look, for all I've done for you, this is what I get in return. So it's a real act of betrayal that he just can't let go of. And that's why he's up at 3 in the morning, ruminating on Christmas Eve morning and Christmas Day morning. And so, yeah, I think the financial stuff really is getting to him. And so, you know, doing the push off the cliff is a lot easier financially for him, right? He's got $250,000 life insurance, so they're gonna tie all those ends up there at the closing. So, and I think as far as right now, you know, anything they've presented, I don't see the prosecution really having to rebut anything. You know, at most, as a prosecutor, maybe just bring the son back to say, "Are you sure? You know, you heard your dad say that he tried to kill her and stuff like that," just to have that emotional connection. Because I think the jurors really connect with the son, and they see him as being like the true like sort of a hero kind of guy. Because a lot of kids would be afraid to testify against their dad, knowing they could put him away for up to life.
Right.
You
Mhm.
know, you know, what reminds me of the moral courage. He reminds me of uh, Dr. Adelson out of New York. I forget his first name. That testified against Rob Adelson. Yeah, Dr. Rob
Mhm.
Adelson
Mhm.
having the courage to testify against his mom of all things. So,
Mhm.
but he knew he was doing the right thing from a justice standpoint. So he's sort of like a junior version of Dr. Rob Adelson. So,
And I think to add to that, talk about contrast. You know, that
mhm.
young man and the integrity he has and the courage it takes to be able to come out and talk against your dad versus his smarmy dad on the stand today.
Yeah, there's some people that are on the chat. Some people are saying, "Hey, get rid of the trolls," but some people say, "Hey, I believe him. I think he's credible," or something like that. And I'm like, okay, well, rest assured, the jury's not going to see it that way. And so,
Agree with you.
yeah, it's he's not fooling anybody. So, yeah, selective
I agree.
amnesia says Boo 22,
Mhm.
and you know, it doesn't, whether there was an actual affair or not, he saw in his mind emails that were betraying the trust. And
Mhm.
remember, he testified that she's not reaching out to him when she lands in
Mhm.
Phoenix and going on her different assignments for the job. All those little tidbits of how her day's going, he's not getting those kind of messages. So he is fuming mad, and he won't admit that he's angry over any of
No.
this,
No,
right?
he has a hard time admitting that.
Yeah, because he knows
Mhm.
anger equals the greatest motivation for murder. So
Interesting.
yeah, life's a journey says rumination, all caps, all day long. Yeah, and
Mhm.
so he
Mhm.
wouldn't even admit that he was thinking about this nonstop, right before he got
Nah,
off the stand here. But
right.
you know, he's going through it financially, he's going through it emotionally, and you know,
Mhm.
it is what it is. So just looking through a few comments here, but
Do you guys see the defense attorneys emoting at all on the camera feed?
I see some of his expressions where he's like throwing up his hands and complaining and sort of sound like he's a sniveling sort of whiner. So
He'll even look out at us at the gallery to try to get sympathy. Puts his arms out and then looks up in the sky
Oh,
and rolls his eyes.
okay, well,
He's done that twice.
yeah, that's not professional to do that. So
Mhm.
he's trying to look exasperated and come on, Judge, come on. I mean, they're not being fair to us, Judge.
Right. Right.
So let's see. Well, I think that's about it, John. We'll take a break here. I'll just keep the chat going.
Okay.
Do you have time to do any mod while the chat's going until we resume?
Sure.
Okay.
Yep. We resume in 45 minutes. So
Yeah.
we'll
Okay,
hang
if
up
you
and I'll
can
get on it.
I'm going to get a break too as well. So,
Okay.
folks, you can stay on and chat. Please keep your chat clean. We're not here to bully people, calling them names. No unprofessional words. Be professional. As if you're sitting there talking to the judge about this case, as if you're sitting there with the judge on this case. And so I will say this, John, before this came on, I was surprised that judge kept out that part, which I thought the prosecutors mischaracterizing it as character evidence to show that this Dr. König was basically so controlling that he was basically wielding and pressuring to go public with more folks exposing his wife's dirty deeds, if you will, if he didn't
Mhm.
get the sex benefits that he expected out of her. So that's what I think is something that the prosecution mischaracterized. I was surprised the judge didn't let it in, but instead he's letting in something having to do with the ex-wife, which I think is like, that's sort of like not enough to, I think, worry about and bring it into this one. But I think his manipulation and coercive nature and the way he tried to lord pressure over his wife in any manner possible, like, hey, you're going to read this book. Hey, you're going to, do this for me. Whatever it is, it shows extreme controlling. And so, yeah, nasty's like someone saying, yeah, the judge is keeping that out, which surprised me. But in the end, it's not going to matter because the jury gets it.
I agree with you 100%. I think this jury's locked in and knows what's going on. And do you expect a quick verdict when this is all done?
Yeah, I can see this being a couple hours and 2-3 hours. So I can't see it going any longer. If they go any longer, then I would say that you got one potential holdout,
Mhm.
and but I don't. They'll get them to see their side of it. I don't see anybody holding out for this. So he's facing up to life with parole, but
Mhm.
since it wasn't an actual murder here, I don't see him getting life at all. So he could get anywhere from, based on her injuries, I could see the fact that it looks like he really did want her dead. I can see him getting maybe 25. So don't know if this judge has some I guess maybe pro defense type views on things. So maybe he'd get something like 15 years or whatnot. But normally in a
Right.
case like this that's getting world publicity, I would say
Mhm.
he's going to get at least 25 years is my guess. It's just a wild guess. I
Okay.
don't know if the justice
Right.
system, but um, do I think he's going to get life potentially? That's potential, but maybe not with this judge and that kind of system there. So it's anyone's guess at this point. But I would say he's going to get probably at least 25.
Okay.
So anyway, and if he gets 25, what percentage is he going to actually serve? I mean, he could be out in a quarter of that time. You know what I mean?
Mhm. Mhm.
So I think a lot of it, if a judge knows how early they're eligible for parole, what the track record is, so a
Mhm.
judge would factor that into the sentence. A jury, if a jury decides a sentence, then they would not. Like here in Texas, a jury decides punishment. They're in excuse me, they're in Hawaii. I don't think the jury would decide punishment. That's a very rare thing.
Okay.
But in any event, let's go
All right,
take a
Carl.
lunch break now, and
All right.
we'll be back. Well, let's
Okay.
jump on right before the trial starts again.
Okay. Aloha.
Okay. All right. Thanks.
Bye.
All right. Taking a break now. Let me put a banner here. So that would be 6:30 Central Time, so 7:30 Eastern Standard Time. All right. Thanks, folks. Okay, starting back up here. They're going to be joining us here in a few minutes. They're in Honolulu. And lawyers are there ready to go, according to John. And so I still think that there is no way any jury is going to believe his story about he's a jagged rock to bash his wife's head in because she was grabbing him by the testicles. That's just not how real life works. He's not going to do that. That's not self-defense. Sorry. If that really was happening, he would have reverted to some other means to stop the pain. Taking a rock and bashing your wife in the head, no, that's not credible at all. So, yes, that's like a massive escalation of potentially deadly force. Taking a rock, trying to crush a skull, and then the guy just disappears in the park for 8 hours because he realizes life is over. Yeah, it's just a very sad situation here. This guy, he had a perfect career. He's got wonderful kids, no doubt. We saw his oldest son, Emil, and just threw it all away. Yeah, the son resolves it. It's his own biological. It's not Ariel's biological. So, and he confessed to the son. So anyway, yeah. Don't have a black cat. Have several cats. None of them are black, but one's a Bengal mix with tabby. The other two are tabby with some Bengal from little LJ. Okay, let's see. Don, you're saying she started back down the trail after a couple pics she took from the tree. That made him mad because she wouldn't go close to the edge for a selfie. That's when he attacked her. Chris Best, is he looking at attempted murder or lesser charge? I think that based on the son, they're going to get the attempted murder. An admission to your own son, that's pretty solid evidence. All right, here we go.
One CPC -25-873. Dr. König is present in court with all full counsel of record. All jurors are back in the courtroom. Dr. König, if you could return to the witness stand. You're still under oath, and Mr. Garner, you may continue on with your cross-examination.
Good afternoon.
Good afternoon.
I'm going to publish State's Exhibit 115, page 1. All right, Dr. König, isn't it true that on January 9th, 2025, at 9:10 p.m., you used the Microsoft Edge browser to log into Ariel's computer backup?
I don't
Yes.
remember.
So what
Now
you're
it's gonna
logging
say
into
yes.
that this exhibit shows is a backup of Ariel's hard drive created in 2011, correct?
No, it's a portable hard drive that she had that had old documents on it.
Okay. And you wanted to go into Ariel's old hard drive to look at the documents, right?
That's right.
And again, January 9th, 2025, 9 p.m., correct?
Yes.
Or 9:10 p.m., correct?
Yes.
So, and this is through a program called Memio, right?
I don't know what Memio is.
Well, regardless, you go in and
No.
you look at your documents, correct?
Yeah, I just go in and look at the documents. I don't know what Memio is.
All right. So you go into the folder for ARI, correct?
Yes.
Then you go into the documents folder, right?
Yes.
And you go into the divorce folder, correct?
Yes.
And in that folder, you open a document called notes. Is that right?
Yes.
Okay. Moving on to page 2 of the exhibit. This is the same folder, correct?
Yes.
Okay, the ARI folder. I'm sorry, this is a different folder. This is the ARI folder and then the downloads folder, correct?
Yes.
And the document you're looking at 9:14 p.m. on January 9, 2025 is called Complaint for Absolute Divorce. Is that right?
Yes.
And page 3 of the exhibit, this is also in the downloads folder, correct?
That's correct.
And the document you're viewing at 9:15 p.m. is called Rosen-Divorce. correct?
Yes.
And again, these were all on Ariel's external hard drive, correct?
Yes.
On February 3rd, 2025, you go back to your prior divorce folder. Is that correct?
I don't recall that at all.
Publishing States Exhibit 113, page 4. On February 3rd, 2025, you go back to your divorce folder from your prior divorce to Jessica Batella Ray. Is that correct?
I do not recall doing this at all.
And this is, again, looking at the account statement from your father's account that you moved money into for your loan purposes. That's correct?
It looks like it's the same credit card. I can't remember if it's the same statement date, but it's that same PK Chase Freedom credit card that we used to transfer a balance into to pay it down.
And the last access date and time from the computer system is February 3rd, 2025 at 8:42 a.m., correct?
The last access date and time from the computer system is that date and time. That's correct.
So between December 14th and February 3rd, there are 4 different accesses to your prior divorce folder on your computer, correct?
From the computer system, yes.
That you have no recollection of.
That I have no recollection of.
But you are looking at Ariel's documents on her hard drive about divorce, correct?
Yes, I did look at that divorce folder on her portable hard drive on that date and time.
And during that time period, you're also looking into Ariel's old pay stubs, right?
Yes.
You're also looking into your tax notes that include information about how much alimony and child support you paid, right?
Again, I don't recall looking at a 2018 tax notes during that time, but that tax document was accessed by the system at that time, and that tax document does include alimony and child support.
And you're researching these financial documents and these divorce documents because you want to see how much damage you're going to suffer in a divorce. Isn't that right?
That's not right.
In January, you also review your wedding documents again. Is that correct?
I don't recall. Maybe show me what you're discussing.
On January 22nd, 2025, you access your wedding spreadsheet again, correct?
I might have. I don't specifically recall.
Published dates 124, page 11. The access date is January 22nd, 2025, correct?
That's correct.
And this is another spreadsheet with the same material we talked about earlier, correct?
Yeah, that's another
Guest list, right?
version of the wedding spreadsheet. Yes.
It's got your guest list on it, yes?
Yes.
It's got your task that each of you have to do.
Yes.
It's got the financials, right?
Yes.
And on the same date, January 22nd, 2025, at 3:04 p.m., you view a document called Worthington König Wedding Room Block 9.14.18, correct?
I don't remember doing that at all.
You have no recollection.
I have no recollection of doing that.
It's the same date as the Excel spreadsheet, right?
Yes.
We're going to publish dates 124 at page 12. And again, if you can look, the file system last access date, January 22nd, 2025 at 3:04 p.m., correct?
Yes, I see that.
And in this document, this is the reservation for the venue of your wedding, correct?
That's right.
And it specifically shows how much that cost. Isn't that right?
I have no recollection of what's on that document.
No recollection. Okay, we'll publish to the next page. There's a table in the middle right here, isn't there?
Yeah, and that's the guest room block. So that shows if our guests decide to stay at that hotel, what they would pay under the wedding rate for those 3 different rooms.
We'll move on to the next page. This is basically rules that you have to follow, or what you have to decide what the rules are.
Very calculating, pulling up all this
And
information.
this has an anticipated revenue section, correct?
Yeah, so they had a minimum. So we were holding our wedding at this venue, and they had a minimum revenue that they needed to generate from room reservations from our guests, and that was the minimum.
And the overall cost for your wedding was $55,000 approximately, correct?
That sounds about right. I don't recall the exact number. But
Then you were
is
looking up-
that in that document?
Asked
that-
you in general.
No. Oh, I'm just wondering where you got your number from.
The overall cost from your wedding is from your spreadsheets, correct?
Yes.
So you're looking up multiple different spreadsheets with the cost, right?
I have no recollection of looking at the wedding room block document. I don't have a recollection of looking at the wedding spreadsheet either, but I could potentially think of a reason why I would have done that. But I've no recollection of opening that wedding room block and have no idea why I would have done that.
The next date that you open the wedding spreadsheet is February 24th, 2025. Isn't that correct?
I don't remember opening the wedding spreadsheet, but
You don't recall? Okay. You also open a document called Final Floral Proposal on March 14th, 2025. Isn't that correct?
no, I don't think I did. I don't remember doing that. And if that's related to the wedding, I certainly did not look at the floral contract or whatever. What is it called?
You're saying you did not look at the floral contract?
No.
or the final floral proposal. Is that
I don't
right?
recall how
I
you know.
100% did not look at the final floral proposal for our wedding in March.
The published states 124 at page 21. The document that we're looking at has a file name of final floral proposal, correct?
That's correct.
File system, last access date and time, March 14, 2025.
Yeah, the computer system accessed it on that date and time. I have no recollection of opening this document and looking at that date and time.
The computer system did all this.
Yes.
The computer system opened this document is what you're saying today.
I'm not sure what
Where
the
does
computer
access
system
go?
did. It says
Okay.
accessed. That is what the computer
It
system.
says access.
The computer system accessed this document, right?
That's correct.
Okay. On January 22nd, 2025, you viewed a UBS portfolio detailing your and your wife's retirement accounts, correct?
That's correct.
And that was a statement from December 2004, correct?
2004?
2024, correct?
Yes.
So in December 2024, you get the UBS statement detailing how much you and your wife have in your retirement accounts. Is
That's
that right?
correct. Yes.
And you reviewed that on January 22nd, 2025.
Yes, I do remember that.
And this is actually within a month of getting the statement, right?
That's right.
It makes sense to review the statement, within a month of getting it, right?
Yes.
Do you remember the figures in the statement?
I do not.
Would it help if we go through them together?
Yes.
States 126. We'll publish starting with the first page. This is just the metadata again that shows you you accessed this on January 22nd, 2025, correct?
Yes.
And again, statements from December 2024, right?
Yes.
Okay. We're going to look at a page detailing your Roth IRA, your Roth IRA next, okay?
That's
Okay, here's a summary page, correct?
too comfortable.
Yes.
All right, and Gerhardt König, you have in this UBS account an Roth IRA value of $8,066.95, correct?
That's correct.
Ariel König has a Roth valued at $74,974, correct?
That's correct.
Ariel König has a second IRA valued at $164,500.76, correct?
That's correct.
For your account, that's a little over $8,000. Ariel is the sole beneficiary. Is that right?
That's right.
Anything happens to you, she gets 100%, right?
That's right.
For Ariel's Roth, the one that's about $75,000, you are the sole beneficiary, right?
That's right.
Anything happens to Ariel, that money goes to you, correct?
That's correct.
For Ariel's IRA, valued at $164,000 approximately, you are also the sole beneficiary, correct?
That's correct.
Anything happens to Ariel, that $164,000 goes to you. Is that
That's
right?
right.
In January 22nd, 2025, that's about the same time that you're doing all your life insurance work, right?
That's right.
And that's around the same time that you send Ariel that email instructing her to get a $250,000 life insurance policy, correct?
I did not instruct her to get that. It was a discussion that we had together, and the email was a summary of the product and the person to talk to after I contacted AAA. So I wasn't telling her to get life insurance. It was here, contact this guy and ask for this product to get the life insurance that we discussed.
And you sent that on January 21st, is that correct?
I don't recall the exact date, but that sounds like it's the right date.
On February 4th, 2025, you viewed a May 2022 pay stub for Ariel, isn't that correct?
I'm sorry, say that again?
On February 4th, 2025 at 2:29 p.m., you viewed a May 2022 pay stub for Ariel, correct?
I have no recollection of that.
We'll publish States Exhibit 125 at page 22. This is the metadata, correct, Dr. König?
Yes.
And again, the document we're looking at is a pay stub, correct?
That's right. There's one pay stub from 2022 at the end of May.
And this is in your taxes folder on your computer, right?
Yes, that's in the shared drive in the taxes folder. That's correct.
But your testimony today is you have no recollection of looking at this.
I have no recollection of looking at this
And the information contained in this pay stub is only the amount Ariel got paid that 1 month,
for
right?
that 1 month, correct? Yeah, it doesn't make any sense that I would have looked at 1 month of pay stub data from 2 years ago at that time.
If he recalls, then he has to know the reason why. And so he's just saying, I don't remember. I don't recall. Oh, I must have. Oh.
On March 14th, 2025, you viewed a 2018 Wealthfront account statement for Ariel. Isn't that correct?
I don't have any recollection of that.
Published States Exhibit 125 at page 24. Now, again, this is about a 2018 statement, correct?
That's correct.
And this is a statement for an account, a retirement account, or sorry, an investment account belonging only to Ariel. Isn't that correct?
Yeah, but I don't even think she still had it at this point in time. So this was a
Objection, non-responsive.
yeah. I have no recollection. I have no recollection of looking at this document.
Ask the question.
This
You know-
document is from 2018, correct?
That's correct.
After the break, his memory's
And
gotten
again-
worse.
No recollection.
No recollection.
Wonder why that is.
On March 16th, 2025, you viewed a document, again, about Ariel's retirement accounts, correct?
I don't have a. I
Look at his
might have.
eyes. Flutters his eyes, saying, I don't remember.
In a published States Exhibit 125 at page 36. On March 16th, 2025, you accessed a document that belongs or that is about Ariel's financials, correct?
This is on my desktop. I don't know what's in that document.
So this document isn't actually even in your taxes folder, right?
Right. This is on my desktop.
Meaning every time you open up your desktop, you see this document, right?
No, I have probably 3 dozen different random documents that just tend to collect on my desktop. If I copy something and email it, sometimes I put it on my desktop for, during that time. I was not aware that this was on my desktop. I'm sure it was. That's the location of it. And I don't remember what this document is at all.
This document is again from 2022, right?
That's correct.
And this is showing how much Ariel had in her Westinghouse retirement account in 2022. Is that right?
I can't answer that unless I can look at the document.
We'll publish the next page. This is a similar document to one that we viewed this morning, right?
Yes.
Okay, and it tells you in the top right, which I'll zoom in on, how much Ariel had in her retirement account as of a certain date, correct?
Yes. It says the total value of that account. And what's the date?
The date was, the account summary shows 2022 in November, correct?
Oh, yeah.
So this document is about Ariel's retirement account from November 2022, correct?
That's correct. Yeah, I remember looking at this. I did look at this.
Okay, now you do remember looking
I
at
do,
this.
yes.
Okay. And November 2022 is a couple years before March 2025, correct?
That's correct.
It's 2.5 years, right?
Yes.
Now, you've been asked about your research into hiking, is that right?
That's right.
And you testified yesterday that you do a lot of hiking, right?
I do.
Isn't it true that there are only searches and computer data related to hiking between the dates of February 28, 2025 to March 4th, 2025 on that computer.
That's correct.
Well, objection. There was a search range in the search warrant.
Do we speak in objections?
There was a search range in the search warrant. This question was about the entire computer.
Approach.
All right, so yeah, all this kind of detail about what he's searching for financially, the more financial stuff they show that he's searching, the more the jury gets at that he could not afford another divorce in his mind. It was just too painful to have to start over. And so,
Let's limit the time frame, Dr. Koenig. Between December 2024 and March 2025, the only data related to hiking from your computer is for those 5 days, correct?
That's correct.
And in January 2025, you actually treated a woman in the course of your work for having a rock fall on her at a waterfall. Is that right?
That's right.
You saw the injuries that she got from that rock, correct?
I did.
You saw what kind of treatment she needed, right?
Yes.
And in February, at the end of February, that's when you started researching hikes, correct?
That's correct.
Published states 111. Publishing states 111, page 1. On February 28th at 2:55 p.m., you searched Maui secret hikes, correct?
I did.
Then on the same date at 3:13 p.m., you searched secret hike Waikamai Falls, correct?
That's correct.
Then a couple minutes later on the same day, you move on to Oahu, correct?
Yes.
And you search best Oahu hikes, right?
That's right.
And by this time, you know that you're going to be taking, or you've discussed this Oahu trip with Ariel, correct?
Yes.
And the start of your search for Oahu is best hikes Oahu, right?
That's right.
And then you go to a website called alltrails.com, correct?
Yes.
And you filter to Hawaii first, right?
Yes.
And then Oahu, correct?
Yes.
And the title of that website is the 10 best trails and hikes in Oahu.
That's right.
Okay. The Palipuka Trail is not in those 10 best trails, is it?
I can't remember, but I don't think so.
Publishing next page to page 5. So February 28, 2025, 3:30 p.m., you click on a YouTube link titled Easy Hike on Oahu, Makapu'u Lighthouse Trail. Is that right?
That's correct.
Okay. And just a couple seconds later, publishing the next page, again at 3:30 p.m., you click on a different YouTube link for the top 10 easy Oahu hikes for everyone. Is that right?
Yes.
So first you look at best hikes, right?
Yes.
And then you see these 2 YouTube videos for easy hikes, right?
Yes.
You don't watch these full videos, right?
Probably not.
You don't watch these videos because at next page, 7 out of 10, 3:31 p.m., you're looking up difficult hikes, right?
That's right.
Because easy hikes is not for you, right?
Yeah, the hikes that I found on the Easy Hikes website wasn't what we were looking for.
easy hikes won't have cliffs.
Difficult hikes are generally more dangerous, right?
Sometimes.
Difficult-
Sometimes they're just longer.
Difficult hikes have rougher terrain, right?
Sometimes.
Difficult hikes have higher drop-offs, right?
Not necessarily.
Difficult hikes can have more exposure, correct?
They could.
And these difficult hikes, these are the kinds of hikes you were interested in, right?
Yes.
Now, your search for difficult hikes brought you to a website called journeyera.com. Is that right?
That's right.
And the first page you looked at on journeyera.com, I'm going to scroll to page 8 of this exhibit, is the URL just says Oahu hikes. Is that right?
That's right.
And again, you're listing Journey Era on February 28, 2025, correct?
Yes.
So this is still the first day that you're researching hiking, correct?
That's correct.
And moving on to the next one. Next page, page number 9. You end up going to a page on journeyera.com saying the 35 best hikes on Oahu, the ultimate guide, right?
Yes.
Although the URL talks about the Stairway to Heaven, this is actually a list of 35 hikes, correct?
Yes.
And on that list, you see the Palipuka hike, correct?
Yeah, among 34 others.
And then On March 3rd, 2025, you go back to the journeyerror.com website. Is that right?
That's right.
And this time you're going to look at the Polypuka hike page specifically, correct?
That's correct.
Okay. March 3rd, 2025, 7:19 a.m., correct?
That's correct.
And you've seen the website you looked at up on the screen, yeah?
Yes.
Okay, we're going to put it up and go through it together. All right, this is the front page of the website, right?
Yes.
All right, we're going to go to page 2. When you read this, you saw that sentence that says, the Poly Lookout itself is a popular tourist spot, but 99% of visitors to the lookout don't hike. They just look over the valley. You saw that sentence, right?
I'm sure I did. Yeah.
And then you saw the page that describes the hike, isn't that right?
That's right.
You read the description?
Yes.
So you read the description that says, the hike isn't necessarily dangerous, but much of the path is on the edge of a huge drop-off. You read that, right?
I'm sure I did.
And you read the sentence that says, does that make it dangerous? You decide.
I'm sure I did. I remember reading this whole article.
So you remember reading the whole article.
Yes.
You remember reading the part that says that the hike spits you out on the edge of a cliff with a huge drop-off.
If it says that, then I read that.
You remember looking at this picture of the hike, right?
Yes.
And you see this picture, and this is what you want to do.
Yes.
This is the hike you want to take Ariel on, right?
Yes.
Next page. In this page, the author describes and shows a picture of themselves enjoying themselves, right?
That's right.
They're looking out over the entire windward side. Is that right?
That's right.
And this picture on this side has the puka. Is that right?
That's right.
And this is at the end of the hike, right?
I assume so. Actually, from what I've remember from the description is that you can keep going past this for a little while still, but it's close to the end.
And
I've
this
never-
is
I've never
ultimately
been
where
there.
you want to take Ariel, right?
Yes.
This was the plan, to take her to this section, correct?
Yes.
And to take Ariel to this section of the puka, you have to take her through this section, correct?
Yes.
You have to take her along this trail along the cliff. Is that right?
Presumably, I never got to this point in the trail, but according to the pictures, yes.
You never got this far on the trail, right?
No.
The plan was to get that far on the trail, though, right?
Yes.
And then you saw the end of the article. Sorry, I'll put it back up. You saw the end of the article where it gives you advice, right? Where it says, be safe going down and take it slow as it can be slippery and the drop looks very unforgiving.
Yes.
You read that, right?
Yes.
Now, while this is all going on, you've also been working on updating the insurance, correct?
Yeah. So we applied at the end of January, and this was March 4th. Yeah. By this time, I think Aries policy had already gone through, and either one and maybe one of my policies did, but not both.
Your insurance policy doesn't go through partially until March 12th and then completely on March 24th. Is that correct?
That sounds right.
Wow, just in time.
On March 17th, you actually search up Ariel's profile on Facebook again. Is that correct?
I don't have a specific recollection of that, but I probably did.
And on March 4th, 2025, you were also looking at WhatsApp again, correct?
Probably. I was using WhatsApp every day
You were using WhatsApp every day.
for work.
Now, Okay. And you testified yesterday about your work bag and the medication that was in it, right?
Yes,
And you testified that your work bag is used for when you're on call, correct?
that's correct.
And you testified that you normally keep medication in there to provide if it's a rush situation, right?
Yes,
And the medication that you keep there can be dangerous, correct?
that's correct.
The medication that you keep in that bag can kill somebody, right?
I'll have to look at the medication that's in there, but a lot of the medications that I use at work can be lethal if not given appropriately.
Well, it's published States Exhibit 98. Can you see the vial on the bottom right of this bag?
Yes, I can.
Do you need me to zoom in so you can read the label?
No, I know what that is.
The trade name of this drug is called Diprivan. Is that correct?
That's correct.
The actual name of the drug or the scientific name is called propofol, correct?
That's correct.
Propofol is one of the main drugs that actually, I'll use a non-scientific word, puts you to sleep during anesthesia, correct?
It's a very common drug that we use to initiate and sometimes maintain anesthesia.
Propofol is rather famous, right?
Yes,
Propofol is the drug that killed Michael Jackson. Is that right?
that's right.
You've heard of that story, of course?
Yes,
It is not a controlled substance. That's correct?
that's correct.
And you actually have a controlled substance license yourself too, right?
I do.
So you can carry more dangerous drugs than propofol, correct?
Yeah, I don't think I can. I think because my controlled substance license doesn't allow me to dispense. It just allows me to administer. And so all of our controlled substances are controlled at all of the locations where we work. And so we have to check them out and check them back in and then document all of the vials that we used during the day. I've never taken controlled substances home. I would never. It's not something I want to get into. So I don't even know if it's allowed under my license, but I could administer it.
Now, let's take this exhibit down. And let's talk about March 24th, 2025. It was a normal morning, right?
Yes.
You and Ariel weren't fighting when you woke up at the hotel, correct?
No.
You gave her that birthday card, right?
Yes.
And then you and Ariel go to the bakery and get breakfast, correct?
No, we went and got breakfast in the hotel.
Got it. And then you go to the bakery to get coffee, right?
Coffee and pastries, yeah.
And then you and Ariel head out in your rental car up to the Poly Puka. Is that right?
That's right.
You drive up the Poly Highway, right?
Yes.
And you park in the parking lot at the Poly Lookout, correct?
That's right.
And you knew from your research into this hike that 99% of the people up at that lookout would not be going on the trail, correct?
I didn't know the actual amount, but I knew the lookout was popular and the hike was less popular.
And that actually said 99% versus 1%, right?
Where did what say?
The website you researched.
The Journey here article. Oh yeah, that did say that.
The website even told you, does that make the hike dangerous? You decide. Is that right?
No, the website when the website said that, it was talking about the trail being next to a cliff, not the trail being some isolated, secluded spot that there's no people.
The website said you decide if the trail is dangerous, correct?
No, the website said specifically, it's not dangerous if you stay on the trail, but if you don't stay on the trail, you might fall off the cliff. Is that dangerous? You decide.
Boy, good memory.
And you saw that cliff, right?
I did on the picture.
And you saw that cliff was at minimum several hundred feet high, correct?
Yes,
Wow.
You know, common sense tells you somebody falls off that cliff, they're going to die, right?
that's correct.
And the website even tells you that the hike spits you out on the edge of a cliff with a huge drop off. Is that right?
That's right.
And that photo that we looked at shows the trail going right along the cliff edge, correct?
For parts of it.
And this is the hike that you wanted to take Ariel on for her birthday, right?
Yes.
You wanted to go through the start of the hike, correct?
I'm sorry. Can you say that again?
You wanted to do more than just start the hike, correct?
I wanted to do more than just start the hike. That's correct.
You wanted to do the whole hike, is that right?
That was the plan.
You wanted to take Ariel through that cliffside path that we saw in that photo, correct?
Yeah, I wanted to take her on the hike and go with her on the hike and make it all the way to the puka. That was the plan.
In Publishing States Exhibit 122, you wanted to take Ariel along this path, right?
That's right.
Wouldn't you agree that that path is right on the edge of the cliff?
Yeah, it's very, very close to the edge of the cliff.
It's a narrow path, right?
It's a narrow path, and then there's a little narrow strip of grass and rocks, and then there's the cliff.
An empty void, right?
Yes.
Nothing to hold on to, right?
For this part of the trail, not much. I mean, there's some brush on the other side, but you have to really watch your step.
But Ariel didn't go that far on the trail that day, did she?
No.
Because Ariel didn't want to hike anymore, right?
Yeah, there came a point in time where Ariel did not want to hike anymore.
Ariel deviated from your plan to go up this part of the trail, right?
I wouldn't characterize it like that.
Well, you planned to go up this part of the trail, correct?
That's correct.
And Ariel didn't follow through with that part of the plan, right?
Yeah.
And at some point, you actually continue up the trail yourself, right?
That's right.
Without Ariel,
That's right.
on her birthday.
That's right.
But she didn't follow you, correct?
No.
She didn't follow you up to this narrow trail with this massive cliff, correct?
That's correct.
Good for
And then
her.
you went back down, isn't that right?
That's right.
And you saw that she was still there, right?
Yes,
And it was a surprise to you, right?
it was.
It was a surprise to you because you still had a chance to go through with your plan, right?
What plan are you referring to?
It was a surprise because you still had a chance to go through with your plan to push Ariel off the cliff. Isn't that right?
That is not right at all.
The area where you and Ariel ended up still had a massive cliff next to it, correct?
Yes,
The area where you took the selfie had a massive cliff behind it, correct?
that's correct.
It would work just as well as the area in this photo to push somebody off, correct?
It would work just as well to push somebody off. What do you like? I don't understand the question.
Well, somebody would be just as dead if they fell off this part or if they fell off the part where you guys ended up.
Absolutely.
Yes.
They would be as dead falling anywhere along this trail because the cliff is extremely high.
I'm going to take these a bit down. Before we get to the final parts of the trail, you testified this morning and you said, please do correct me if I'm wrong here, that you were not sexually demanding of Ariel. Is that correct?
That's correct.
That is your testimony.
Yes,
You and Ariel went to couples counseling, isn't that correct?
that's correct.
And when you went to couples counseling, you testified about the counseling yesterday, right?
Yes.
And
That's a topic the defense does not want brought in, and there was a motion in limine, meaning outside the presence of the jury, the judge had restricted any reference to any kind of sexual control that he exerted over his wife. So I'm not sure why the prosecutor asked that because that was to be kept out. And so we'll see what happens here. But I just noticed a difference from the time we had the lunch break to the time he's testifying now. Suddenly he has more memory. I wonder if his defense attorneys told him, like, look, dude, you're not doing very good with all this. I don't recall, but yeah, I guess I must have, but I don't remember anything. So now he seems to have better recall on things. And now he has perfect recall on certain things also. Just like the website, he'd correct him on exactly what the website for this probably Buca Park says. So yeah, this guy's selective amnesia is not going to win over the jury. Yeah, and he sure well understood that question. He played stupid so he can buy some more time to try to come across a smoother answer. Yesterday, I noticed he had no appropriate emotional behavior when he testified. You didn't see any indications that he felt bad for his wife, that he felt a loss by his wife and their relationship falling apart, now him falsely accused. He's not acting like he's angry about the fact that he's falsely accused. He's acting way too comfortable. Yesterday, he couldn't wait to spit out answers. Today, he's more sedate, but very, very much he's being evasive with a selective memory. There's somebody in here that said she embellished her testimony talking about Ariel. And she's all making it up, try to control the outcome for divorce. Yeah, well, the problem is I don't see that any of his actions were consistent with an innocent person. None of what he described is consistent with an innocent person. 46-year-old male at the time. Lamar's asking, did they ever find the syringe? No, not the one out there on the trail. I hear CMD pieces. I don't know if you're a troll, but you're saying her testimony is completely embellished. She lied throughout the whole testimony. Don't be fooled by her side of the story. She wants everything. They'll only take it all to destroy him. I mean, that sounds more like a troll type comment, so I'm considering deleting you. So I don't mind differences of opinions here, but when you come across so strongly like you're an insider and you know exactly what happened, then it sort of like comes across as trollish. Oh, here, John says that Dr. König looked out at jurors. None of them looked back. Yeah, I don't think he wants to look over at the jury much. I will say also, look at his dress. He doesn't even have a tie on, doesn't have a jacket on. I'm just surprised he's a doctor. So why is he dressing so casual like? It's very unusual to see. I mean, you see like construction workers making $15 an hour wear a sport coat at least, or a suit and tie. So for a medical doctor, just dressed like that, it's just not, I don't think he's dressed appropriate given the fact that he would own some suits, no doubt. So maybe he's just trying to be more relatable to the jurors. So I understand he lives in Hawaii, more laid back dress culture, but it's still a court of law. So maybe he's trying to fit in with the jury because that's how they're dressed. I'll text John here and ask him how History. I doubt they're in shorts and flip flops. Yeah, Jackie Smith says his son on the stand put the nail in his coffin. Yeah, I think that was a real clincher, is his son testifying.
Dr. König, just to clarify one more time, you testified this morning that you were not sexually demanding towards Ariel. Is that correct?
I think the question was if I ever demanded sex of Ari, and I've never demanded sex of Ari.
So you never demanded it, right?
That's right.
How often did you want to have sex with Ariel?
There was no specific number of times.
It was up to every other day, right?
Was what up to every other day?
You wanted to have sex with Ariel and an amount up to every other day. Isn't that correct?
At some point in our relationship, we had sex, I'm sure, every other day for, that period of time. But there was never a point in our relationship where what's the question?
So in December 2024,
Okay.
after you confronted Ariel about this relationship, you
Yes.
still wanted to have sex with her every other day.
That is not true. We had sex for a portion of December, and it was not every other day. And I never demanded to have sex with her every other day in December or at any point in time in our relationship.
And after December 24th, she did not have sex with you again, correct?
After December 24th, we did not have sex again.
And you testified yesterday that you went to couples counseling, correct?
That's correct.
And you testified that there were other issues, right?
That's right.
And one of those issues was an intimacy issue, correct?
That's correct.
And the couples therapist you saw, at least one of them was named Gemma Cannon, correct?
That's right.
And she had a meeting with you in December 2024, right?
She met with both of us on December 27th.
December 27th. So this is the same day as you had this continued fight with Ariel, right?
We had, I would say, two arguments, two big arguments in December, and one was around the middle of the month, and the other one was on the night of December 26th, and then we argued about it again on the morning of December 27th, right before counseling. That's correct.
So you went to counseling with both you and Ariel, correct?
That's right.
And you both told the counselor what your problems were, right?
Yes.
And the counselor, Miss Cannon,
Objection. We're hearsay if we're getting into what somebody else said.
It's substantive, not committed. Overruled.
Excuse me? No.
It's not substantive. Overruled.
okay, so you and Ariel both told the counselor what your problems were, right?
Yes.
Your problem was the same problem you've talked about a lot already, right? The
Yeah.
emotional affair.
The main issue that I wanted to address was the aftermath of the emotional affair, which included a lot of different issues in our relationship. It wasn't just one thing. It was a big kind of,
And Ariel also stated what her problems were, right?
that's right.
And the counselor listened to both of you and came up with a plan. That's right.
That's right.
And the counselor's plan was to deal with the intimacy issues first, correct?
The counselor's plan was to deal with the issues that Ariel brought up first. Yes.
That was the intimacy issues.
Yeah, part of it.
And then she would deal with the affair afterwards, right?
Yes, and not afterwards, but because again, these are not just like things you check off, off of a to-do list. The affair was causing a lot of issues in our relationship, and addressing those issues were going to take probably years. And the issues that Ari brought up, similarly, was also not just going to be a check off the box thing, and it's probably going to take some time. And the counselor said that she's going to start off with the other issues, and not start off with the affair issues, but it wasn't just like we were going to finish the one, check it off the box, and then move on to the next. There's overlapping issues, and it's all to do with the relationship. And so it's not fair to characterize it like we were going to finish one and then move on to the other. But we were definitely going to. She said, we're going to basically let's prioritize talking about the issues that she brought up first. Gerhardt, are you okay with waiting to address a lot of the issues to do with the affair until later in therapy? And I said, absolutely.
And you testified yesterday that those issues about the affair were never really resolved. Is that right?
No. Yes, that's right.
So talked about Ariel's issues, and the issues you brought up were never resolved. Correct?
I'm sorry. Ask that again.
The first priority was Ariel's issues, the intimacy issues, correct?
The first priority was Ariel's issues, and intimacy was one of them.
And then your issue, the emotional affair, was never addressed, correct?
And our issue, the affair, wasn't adequately addressed ever either. And neither were the emotional issues. And I have to say, part of the affair and the aftermath of the affair, I had emotional issues, intimacy issues as well with her. So the intimacy issues went both ways. And when we...
Just
I'm going to ask my next question.
Go ahead, sorry.
Oh, there's defense attorney rubbing his hand in his face. He's like, let's get through this. We got to get
Okay.
to work.
Let's go back to the hike, Dr. König.
Okay.
March 24th, 2025, you testified about the hike yesterday, correct?
Yes.
You testified that you and Ariel had a massive argument, right?
Yes.
You testified that on her birthday, Ariel brought up a subject she knew would upset you, right? I'm sorry. You didn't testify to that, but that is what happened, correct?
That is what happened, yes.
You testified that Ariel brought up that she wanted to go back to work and speak to Jeff Miller again, correct?
She was still working, so she wasn't trying to go back to work. She wanted to start traveling with him again.
And your testimony is that this is what Ariel decides to bring up on her birthday trip with you, right?
Yes.
And that she decides to bring this up on the Polypuka Trail, right?
That's where she brought it up. That's correct.
So you testify that you have this argument, you separate, and then you come back together, right?
Yes.
You take this selfie right by the cliff, correct?
Yes.
And then you testified that Ariel pushed you, right?
Yes.
And you testified that you could barely hold on, right?
I almost went off the cliff.
And then you turned around and you testified that Ariel was 5 to 10 feet away, right?
By the time I turned around, she had backed away, and she was not. And yeah, that was part of why I was concerned that was a shove and not a accidental thing.
And then you approached her, you went towards her.
I did.
So you think you about get pushed off a cliff, and then you go 5 or 10 feet to get to Ariel, right?
I moved towards her. That's correct.
And then you say that Ariel pulled you onto the ground, right?
That's correct.
You're bigger than Ariel, right?
Yes.
You have at least, or at the time of the offense, or at the time of the incident, you had at least 20 pounds on her, right?
Yeah, roughly 20 pounds.
You're stronger than her, right?
Probably.
You're a doctor, so you know that men generally are stronger than women, correct?
Yes,
It's just a scientific matter of testosterone, right?
that's true.
But you testify that Ariel managed to pull you to the ground and she pulled you on top of her, right?
That's correct.
Okay. Then you testified that Ariel wouldn't let you go from on top of her, right?
That's correct.
You testified that she wrapped her legs around you, right?
She wrapped at least one leg around me, yes.
Yesterday you said legs, right?
I think I said leg. It was at least one.
Which is it?
And you testified that she grabbed your testicles, right?
She did.
And that she wouldn't let go, right?
That's right.
All this time, you were on top of her, right?
That's correct.
And then you testified that Ariel took that rock. I'm going to grab exhibit 2 right now. You testified that Ariel took this rock and hit you in the face. Isn't that right?
That's right.
And you said the first hit, she got me kind of good, right?
That's right.
And you said she kept trying, right?
That's right.
And you testified you tried to start blocking it, right?
Yes.
And you testified she actually got a couple more hits in, right?
Yes.
So, but you don't know how many hits, right?
No.
One good hit to the side of your face, correct?
That's right.
Publish States Exhibit 236. This is a photo of you from March 24th, 2025, correct?
That's right.
This is immediately after the police arrested you, right?
That's right.
This is the closest photo of you after Ariel hit you with this rock, right?
That's right.
And publish alongside States Exhibit 1.
Wow.
Okay, so on the right side, we have you after Ariel got one good hit with you with the rock, right?
That's right.
And on the right side, we have you after Ariel kept hitting you with the rock and got a couple other less good hits. Is that right?
That's right.
On the left side of the screen, you testified that you hit Ariel 2 times, right?
That's correct.
On the left side of the screen, we have the results that you say you hit her only 2 times, correct?
That's correct.
Let's move on to the next day. We're going to publish states. I'm sorry, not the next day. We're going to publish states D30 on the right side. I'm sorry, defense 30 on the right side. Okay, look at the right side of the screen, please. This photo on the right side of the screen is you at the hospital, correct?
That's correct.
You at the hospital on the night of March 24th, 2025, correct?
That's correct.
This is you at the hospital after Ariel got a good hit on you with this rock, correct?
That's right.
On the left side of the screen, I'm going to put up states 23. This is Ariel at the hospital, correct?
That's right.
This is Ariel at the hospital after your 2 hits, correct?
That's right.
And you say only 2 hits to Ariel, right?
I only hit her 2 times.
This is the front of Ariel's face after those 2 hits, right?
Yes.
More than 2 hits.
States 22.
Thank you.
Put up states 27. This is Ariel's hand after those. This is Ariel's hand after those 2 hits, right?
Yes.
And lastly, we'll put up on the left side states 1, 2, 8. On the left side of the screen, that's Ariel on March 25th, 2025, correct?
I don't know when that picture was taken, but I'll take your word for it.
That's Ariel the day afterwards, right?
Like I said, I don't know when that picture was taken, but I'll take your word for it.
We'll publish on the right side, states 239. We'll flip it upside correctly.
He looks fine.
And this is you again, correct?
Yes.
This is you on March 25th, 2025, right?
I think that was like the night of, like just after midnight, but it was after the previous picture. That's right.
This is you one day after Ariel hit you really good with this rock, isn't it?
That's right.
I'd put that rock in his hand, have him demonstrate the actions he took with his
Take the recess.
I'm sorry.
Should we take the recess?
That was a good time.
hand.
Ladies and gentlemen, let's take our afternoon recess. Ladies and gentlemen, we'll get to it at 2:45. Leave your notebooks on the chair. All right.
Yeah, he thought he should testify. Deborah Rose is asking that. This is his chance to tell his side of the story, and he just needs to have one juror believe his side over Ariel's, and you can get a hung jury that way. So, yeah, definitely more than 2 hits. I agree with you, Christine Hogue. Great job, the prosecutor, showing side-by-side comparisons. Keep in mind, he's like 5'8". She's a couple inches shorter. He weight difference, I think, is about 25 pounds difference. Strength-wise, male over female, he'd have a lot of strength over hers. Yeah. The only way for him to bring up self-defense is for him to testify as well. So, and it was a slam dunk win against him. His only shot is to testify something that makes Ariel out to be the aggressor. When self-defense is raised as a defense to a crime like this, the prosecution not only has to prove his guilt beyond a reasonable doubt, but they have to prove beyond a reasonable doubt that he did not act in self-defense. So you sort of have a double burden on the prosecution that way. But they'll easily meet those burdens of proof in this case. This prosecutor's doing a really smooth job here. New day. If God forbid I ever need defense attorney, I'll consider skill and likability. Well, you need more than that. More than skill, you need drive, determination, hustle, hard work, fairness of fee as well. There's a lot of bad options you can have as attorneys, whether it's civil or criminal. A lot of bad options. We've seen that. Just look at the criminal trials we're taking. So from prosecutors dropping the ball to defense attorneys dropping the ball, judges missing it, missing the mark. I mean, you got to run the whole gamut. As I've said before, all it takes is someone that's bad in their job as a judge, a juror, a witness, a prosecutor, a defense attorney, or any combination thereof, and you can have an innocent person be convicted. Yeah, so John is saying that on recount, it's 10 women and 6 men on the jury. I mean, for her to decide to Truth seeker, what if she tried to push him? Why did she wait on the trail? What if he reacted to the realization she was trying to kill him? What if he reacted to the realization she was trying? Really, she's going to try to kill him, pushing him off a cliff? Really? I mean, that makes no sense. He could easily overpower her, but she was able to hold on to branches. And she clung on for dear life and was able to deflect some of the blows to the face. Fractured her thumb in the process, a slight fracture. Okay, well, HTC, if he wanted to kill her, push her off a cliff, as far as needles, etc., that's laughable. I believe him. She clearly wasn't into this marriage. As if a doctor on a busy trail would attack wife. Okay, well, you're pretty clueless, mister, or miss, whatever you are. So we'll see how the jury decides this. The same kind of people, every single criminal trial, there's people that take the side of the defendant. Look at all those that stood up for Corey Richins. And I told you she's going to be convicted in a few hours. That's exactly what happened. So Murdo, I knew he was going to get convicted. That happened. It's not hard to figure out who's going to get convicted here if you've done a lot of these. And I don't know what the culture is there in Hawaii. I've never been to Hawaii. But if they're like normal thinking Americans, I would say this is going to be a slam dunk for them. I'd say probably most of the jurors, or a lot of them maybe, would at least be familiar with that trail and how dangerous that is. I remember I once had an attempted murder case in Pisa, Italy, as a military case, where my soldier client was accused of attempted murder of an airman, and they were on a 40-foot cliff drop off, and I actually went near the edge, and it was terrifying. I'm afraid of heights to begin with, but it was terrifying. And this was a knife fight, and I can say that if it was a murder case, my client, I believe, would have been absolutely justifiable in killing the guy that was beating him up, and I believe could have easily thrown him over the cliff if he knocked him out. So yeah, you have a whole different sense of survival when you're on the edge of a cliff, and you don't even have to be afraid of heights like me. He probably thought it'd be pretty easy to push her off. Yeah, some of you guys are saying his minor injuries were from the police when they took him to the ground when arresting him. Yeah, that's most likely the case. Stevie Howell says, I feel like if the prosecution teased him about how he failed to kill her 3 or 4 ways, he'd lose his mind up there in a rage. Yeah, Stevie Howell says, she decided to wrestle him on a cliff. Okie dokie, totally believable. Yeah, so really? Do these people actually watch the trial, or are they just coming on just to be naysayers? Yeah, so jealousy is a killer. Gen Z, legal reasonable doubt is a possibility. Yeah, it's a legal possibility, but I would say it's not a factual reality. Not realistic to believe that. that that's going to be the outcome. He's legally, of course, presumed innocent until they prove it beyond reasonable doubt, and it goes to the jury room. So, Mortal Clown, I'm fascinated by the psychological state of those who blow off facts to be contrarian. Well, there's just some people like that. Yeah, they've got to be naysayers to anything and everything they come across in life. They like getting that attention or something. I don't know. I just don't see how people that actually have any experience watching trials and outcomes would believe that. Oh, that's a good one. They call this alpine divorce. It's a thing people are doing to get rid of their spouse. That's interesting. You mentioned alpine divorce. Leslie and I have watched a lot of videos lately on Mount Everest and the Matterhorn, and people that have basically a death wish to go up there and fight all the elements. And there's been situations like that where they leave somebody to die. They steal their oxygen tank, leave them to die when they're the ones trying to save them from dying and stuff like that. So yeah, it's a lot of folks think getting them out in some kind of high altitude place, or maybe on a cruise ship, throw them overboard. That kind of stuff is what we see sick plans for murder being about. Yeah, maybe there's lonely people needing some attention. Patriotic. The son's testimony is very credible to me. I think it's game over. I think it is too. I think the jury really picks up on his very obsessive, controlling nature. Let's see here. I understand he's charged with second degree, not first. So yeah, first degree is a high-level felony in Hawaii involving specific aggravating circumstances such as attempted murder of a witness, peace officer, or judge, or multiple murders. Carries life mandatory sentence of life in prison without parole. That's why he has abolished the death penalty. So that's why they did not charge that first degree. Let's look at second degree. Okay, we're back.
Dr. König is present in court on the stand and still in the role. All full counsel of record are present. All jurors are back in the courtroom. Mr. Barnes, can you continue?
I have no further questions.
Oh, he's done.
Can you read that right?
Yes. Okay, Gerhardt, I'm gonna
Right.
just try to jam through this. I know it's been a long day. You're asked about going into detective mode. Why did you go into detective mode when you saw these things and learned about what Ariel had been doing or communicating, the way she was communicating with Mr. Miller? Why did you go into detective mode?
I just needed to find out details about the relationship.
For you, it was something you were searching for information.
She was obviously deleting things and trying to hide things, and I just wanted to understand what was going on, really.
The extent of the
Yes.
relationship. You were asked about the text messages from 12/1 that started, and that was a Sunday. Remember that?
That's right.
And you were asked about where it would say good morning, and then it went on throughout the day, Christmas lights, what you're doing all day long until good night. And you were asked that there was nothing sexual in there. Were you still concerned that on a Sunday your wife was communicating with another man all day long,
Yes.
even though there wasn't?
Move to strike the last time.
Granted, last answer stricken.
Did the text messages still concern you, even though the word sexual wasn't in there?
Yes.
Sustain.
And move to strike the last answer.
Granted.
Were you concerned by the text messages on that Sunday between your wife and another man?
Same objection.
Sustain. Ms. Lee.
How did you feel about the text messages on that Sunday between your wife and another man?
I was very worried.
Why did you tell Bryant first? Why did you reach out to Bryant?
I reached out to Bryant because he was one of my best friends and I needed advice and I wanted to give him a heads up about what was going to happen on the trip.
When you and Ariel talked about her quitting her job, what was your interest?
My interest was for her to terminate her relationship and her contact with Jeffrey Miller.
Were you going to be perfect? Were you okay with her getting another job?
Absolutely.
Was there a conversation about her looking for another job?
Objection leading.
Sustain.
Yeah, redirect. You're not supposed to leave.
Did you and Ariel talk about what would happen if she quit her current job?
Yes.
And what did you guys discuss?
She was going to look for another job.
You were asked a lot about her move, like this conversation about her moving out and then not. Initially, what was your thoughts about her moving out initially when you found out about it in San Luis Obispo?
I mean, I would have preferred if we could deal with the affair in an isolated environment. And so it would have been preferable if she had moved out.
Did you eventually change your thoughts on that?
Yes.
You were asked about monitoring her communications. Is there anything you learned in the audiobooks about that?
Yes.
What did you learn from the audiobooks about monitoring her communications and her sharing, giving up some privacy during this healing period?
I learned that as part of rebuilding trust in a relationship after an affair, especially in the digital age, it is going to require proactive giving up of some degree of privacy by the cheating spouse.
Okay. Now, you were asked about in December time period, certain things that on your computer, when they ran this access search, indicated it was accessed. Okay, so I'm going to quickly ask you, I'm not going to spend hours on hours on
Okay.
ask you a few questions about it.
Yeah.
The things about Reddit and, the audiobooks and things to do with infidelity, why were you looking up these things in late December?
Because I was working on our relationship.
Were you still having a hard time with it all?
I was.
What about divorce?
I asked Detective Numa about how the search warrant, the computer search only pulled the terms, the relevant terms, and your name wasn't on there. Do you believe, like during this time period, you were also looking at your own financial?
You can't remember.
I most certainly was.
Objection beyond
Oh, you remember that? Oh, well, that's convenient.
Do you believe you were also looking at your own financials at the time?
Yes, I most certainly were.
But you
Cheating.
heard Detective Numa say that search only pulled the ones with her name, yeah?
Yes, I heard that.
You mentioned at the end of the year, sometimes you're saying, you're asked about, I just want you to explain it more. So at the end of the year, when you're doing some tax planning, would you commonly look through certain files?
objection leading.
No. Overruled. You can answer that.
Yeah, and not just tax planning, but just financial planning, like budgeting and things like that, and kind of reviewing like, how our retirement accounts were doing, and it was more than just tax planning.
There was a retirement account of Aries that they brought up. So I
Yes.
wanted to ask you, I think you're trying to explain, but why do you have a recollection of why you might have been looking at her retirement account?
Yeah, so she
Tell
had
the jury why.
she had like almost $200,000 in her retirement. And when we purchased our house, we purchased it through UBS actually. So they actually do home loans as well. And as part of that, they convinced us to move all of her retirement into one of their accounts, which is a managed account. So they charge a fee on it. They wanted me to move my retirement account out of my account too when I terminated my job. But that was after we closed on the house. So we didn't end up doing that before we closed on the house. And I was glad because Aries' return at UBS was very poor for 2024. And so I was looking at her return in 2024 that she got at UBS, and I was looking kind of at historical data. And then I was also looking at her return that she used to get on the same retirement money when it was still held at Westinghouse. And it was part of the process to decide if we were going to switch to her retirement account to a different account and provider to
Total
get a
recall.
better return.
Okay. You know, all these financial documents they brought up, were you trying to like see if it would be cheaper to kill her than divorce her?
No.
There's no other explanation.
You mentioned Darvo and what that meant. Why did that term resonate with you?
Oh, because so it felt like she was deflecting and then also blaming me for now the affair, and then also bringing up other things. And one of the threads that I read in Reddit talked about that idea, and then it used that acronym, and so then I was like, oh. What is this? So I looked up the acronym, and that's what it was. And so then I searched that acronym on Reddit to kind of get more information about people dealing with that specific issue.
You were asked about the 2018 Word document about the 2018 taxes and about the child support and alimony. Well, we talked about this the other day, so just really quickly, what other information was on there?
Oh, everything to do with our taxes. So, yeah, I don't know if you want to go into specifics, but
So it wasn't just the alimony and child support.
that's right.
Do you typically wake up early in the morning?
Yes.
You talked about this the other day, but after looking at the Palipuka on the website, what again? Why did it seem like a good one for you guys? What was the reasons?
Yeah, I thought that was going to be a really good hike for us to do because, like the prosecutor mentioned, it has these expansive views of the entire East Oahu. I'm sorry, West Oahu. No, East Oahu. And that was kind of one of our goals, is to kind of explore the island but kind of see it, so we can get an idea of what the island looks like. It was a relatively difficult hike, which we're kind of used to, and we like hikes like that. That's like a little bit out of the ordinary. And it ended up, at this really cool spot where we could take a picture. It was close to Waikiki, and it was a short hike.
Okay.
Fit into
You
our
wanted
schedule.
to do other things that day.
Yes.
1 second.
I'm surprised the prosecutor didn't go into the hike in much more detail.
Now, you were asked about whether or not during the conversation when you confronted Ariel about the affair in San Luis Obispo, prosecutor asked you if at some point in that conversation you called her a lying bitch and a whore. You remember being asked that?
Yes.
And was this a long conversation you guys had?
Yeah, I mean, I would say we had the conversation about the affair for the entire time we were in San Luis Obispo.
But then that first
on
night-
and off, you know.
That first night, did that conversation get heated and emotional?
It did.
Okay.
It did.
Let me ask you this. It was just the two of you there, right?
Oh, when yes.
And you were asked if you called her those names and you wanted to tell the jury that you did.
Yes.
You could have said, no, I didn't call her that, but you wanted them to know that you did call her those names,
Actually
right?
reading, testifying.
Sustain.
Leading.
You testified to this jury. Well,
This guy's bad.
you admit that you called her those names.
Yes.
And then did the conversation continue and did you guys try to work through it?
Yes.
Okay. All right. Thank you, doctor. That's all the questions I have for you.
Good. Wow, I thought that'd gone.
Case number 1's out, so redirect.
Just a moment.
Take your time.
Actually, before we begin, may we approach on the
Yes.
There's not a lot to go on. And do redirect on because the redirect was not very lengthy. So the recross here, it's not going to be very lengthy. He may just ask a couple questions, sit down. So, yeah, so back to my point here. If I was the prosecutor on this case, remember I expected him, based on all the question about the financial stuff, I thought you're talking about 90 minutes to 2 hours on just the details of that hike. And doing the contrast, we saw the contrast with the injuries and whatnot, but getting to more of the nitty gritty details. Also, they didn't bring up the fact that he hid in the park for all that time, never called 911. He saw the blood on his wife and he's not going to try to help her. He's going to take off like a little coward. And so I would have really honed in on that a lot more and just nitpicked his testimony. This guy's good at detailing stuff. Nothing he says, when I know a witness is lying, I go into such excruciating detail that their memory cannot fill in all the gaps. They just become utterly flabbergasted because they realize they're caught in so many twisted versions of it. They can't remember the last version that they said. And none of the details ever add up with any sense. Put the rock in his hand. Show him simulating the striking blows. So left a lot of meat on the bones there, prosecutor, but otherwise you did a great job. I don't think he missed the mark where they're going to get a hung jury or an acquittal, but I was really surprised by that. Have the whole rock up out of the bag if you need to and have him show all the pointed, jagged edges on the rock.
Dr. König, we're going to keep this very limited.
I never asked about his ring.
I'm going to go through two situations. Situation one, if Ari divorces you, you're likely going to be paying child support, correct?
Yes.
And you know from your last marriage, that's very expensive, right?
It's not that expensive, but
You paid almost $30,000 a year in 2018, correct?
it's not a reason why I wouldn't divorce her if we had a good reason for it. Is all I'm saying.
If Ariel divorces you, if she divorces you, you're likely the one that's going to be paying child support. That's correct?
If we ended up getting a divorce, I would be paying child support. Correct.
If Ariel ends up divorcing you, you don't get anything from her life insurance, correct?
If Ariel, if we get divorced, neither one of us gets either one of our life insurances.
Ariel divorces you, you don't get any of her retirement accounts, correct?
If we get divorced, well, that's not true. I know if we get divorced, Ariel might get some of my retirement account because my retirement account is much bigger than hers.
The question was,
Yeah.
if Ariel divorces you, you do not get
her retirement account, correct?
That's, this is a question of law.
The bigger motive is losing his own. That's what I'd focus on, process.
I know that the retirement accounts are going to be, I know that retirement account division is part of divorce. And I know that there's a lot of things that go into that calculation. I know that my retirement account is much bigger than her retirement account. And I'm not sure what portions we'll be able to keep because it's based on when the contributions were made and things like that.
You know that you're likely not going to be taking her retirement if she divorces you, correct?
Like I said, I don't know what's going to come of all that. It's a complicated. It's much more complicated than the life insurance issue, for example.
And you know that if Ari divorces you, a likely outcome would be 50-50 custody, correct?
It depends on the circumstances of the divorce.
You knew before March 24, 2025 that if Ariel divorced you, 50-50 custody is generally standard, correct?
Yes, absolutely. And that's what I would have been advocating for.
Second scenario, if Ari dies, you don't pay any child support, correct?
If Ari died when?
Come on, don't play stupid.
If Ariel König dies, you're not going to be paying her any child support, correct?
If Ari dies, and yes, I would not be paying a dead person child support. Yes.
If Ariel dies, you get the $250,000 life insurance policy she took out, correct?
Yes.
That your suggestion, correct?
Not my suggestion to take out the life insurance policy. It was a joint decision.
If Ariel dies, you get $250,000 from her retirement, correct?
Yes.
As the sole beneficiary, correct?
Yes.
If Ariel dies, you get full custody of the kids, right?
If Ariel dies, I'm the only parent left. Yes.
No further questions.
If you get convicted of this charge,
Objection.
she gets full custody.
Approach.
All right, Judge Wong finally getting mad here. What made this guy think he has a right to do a redirect? He just automatically does that without even getting permission from the court. Normally, you don't do redirect. It's sort of rare. So, I mean, you're not going to have this ping pong match going on fourth and back. Yeah, so better make sure the judge is okay with you doing redirect, because you know what? This attorney Otaki, he's just going to keep going on and on and on. So, and what he's also doing, and John noted this there as well, this attorney Otaki just goes right on up there and calls a sidebar without even having the judge approve it. He doesn't even, he basically says he's approaching for a sidebar, and he doesn't ask the court before he does it. So it's sort of like he's running roughshod over the judge. And you know what? Doing that in front of a jury, yeah, you're not being likable in front of a jury it's one thing to have a commanding presence in the courtroom. It's another thing to act like you have no respect for decorum and the judge's boundaries. You don't approach the bench without permission. Right here, you're saying this judge allowed him to run the courtroom, in my opinion. Okay, Jen, you're saying good chance, reasonable doubt, no bombshell testimony except the son. And personally, the son just didn't seem believable. Okay, well, that's your outside the norm opinion. And I can tell you from my experience, this is something that's going to result in a conviction. It's not going to take too long. So, Hannah, you're pretty disappointed in the cross at the end. Yeah, I am too. What you do on a guy like this is you break it down second by second what happened, where they're laying, and then what he would have said is so ridiculous. See, they're able to gloss over a lot of stuff on direct. So what you do on cross-examination as a prosecutor, you drill down on the nitty-gritty details, second by second breakdown of where their bodies were in relation to one another, who was doing what. And just gloss all over that.
You were asked about custody.
Yes,
Love your boys?
yes, more than I can describe.
Excuse me?
More than words can describe.
Do you want to fight Ariel for 50-50 custody in the divorce?
Absolutely.
You were asked about how if she died, you would have got $250,000. How much money would Ariel have gotten if you died?
Over 2 million, including the life insurance and the retirement.
Let's talk about that. How much life insurance did you take out on your life for her?
1.5 million.
And that was in this January to March time period.
Yes.
During that time period, you decided to take out $1.5 million of life insurance on your life for her, right?
Yes.
You had more retirement than her.
Yes.
And if you died, that would go to her.
Yes.
They brought up child support. Throughout, when you were your two older kids, they asked you about that. After you and their mom split up, did you pay child support?
Yes.
Did you feel it was the right thing to do?
Yes.
Did you want to do that for your kids?
Yes.
He wants to pay child support.
If you and Ari got divorced, would you be willing to pay child support?
Yes. Absolutely.
Would you do financially whatever you needed to do to make sure your kids had a good life?
Yes.
Thank you, Gerhardt.
Any questions? No other questions. Doctor, thank you. Enjoy your rest. Mr. Otake, does the defense wish to present any other evidence?
Can we approach?
Sure, come on.
So, of course, he set it up right beforehand. Look at the timing of this insurance kicking in right before the murder thing. How many times do we see that over and over again? Folks amp up the insurance, life insurance, right before a murder. Here, he had it where his was, 5 times more than what Ariel had. So it made it, so he's thinking, oh, it's going to make it look like, see, I didn't have any motive to kill her because I had all the insurance, the majority of it on myself, not her, because I'm the main breadwinner of the family. But sorry, you also had, you're still going to get $250,000. Having that comparison, I think, was a good way to hide it. So John's saying Dr. Koenig's back at the defense table, no jurors looking his way.
So, ladies and gentlemen, I'm going to release you for the day. It's a long weekend. I think we all could use the long weekend. I hope we get some rest this weekend. I'm going to have you come back on Tuesday. We'll start up at 9 o'clock on Tuesday. That is April 7th. And based on my discussions with the attorneys, we expect to wrap up the presentation of evidence on Tuesday. And the case will be submitted to the jury sometime on Tuesday for deliberations. So that's what we're looking at in terms of the schedule. And it feels like a long road where we're actually ahead of schedule. So I do hope you have a good, restful weekend. Again, there's a lot of coverage. Don't watch any of the coverage. If it's on when you're having dinner, turn off the TV, walk out of the room. Again, your decision must be based on the evidence presented here in court. So the same 3 rules apply. Don't talk to anybody about this case. Keep an open mind. Do not try to learn about this case outside of the courtroom. All of you, have a safe drive home. Have a good long weekend. We'll see you on Tuesday. All rise.
All right, so gonna see if John can join us again. So yeah, prosecutor didn't go into the trail details much at all. So
Also, I have one question. The jury instructions that we settled earlier, at this point in time, court is not contemplating any amendments as we settled them. Mr. Garner, anything on that issue for the state?
No.
How about you, Mr. O'Connor?
thanks, Sharon Joy. Happy Easter.
Can't
Good
think
Friday.
of anything that happened today that would change it.
Be safe there,
Counsel, can I ask you
Israel.
for a favor? Because I know you're living.
Yes,
in this
defendant
case.
is in custody.
There is something I need to revisit. Can you let me know, first thing Monday morning?
This guy loves paying child support. That's nice to see.
Yes, absolutely, Your Honor.
Mr. Garner, anything else you want to take up on record before we adjourn for the week?
I may want to revisit the tailoring issue I made in terms of closing.
You want to take that up now?
Sure. The cases that I'm aware of so far are Walsh and Walsh is the main one, right? Walsh is the most recent one, and that involved the prosecution essentially arguing in closing argument that the defendant can't be trusted because they've sat through and locked in contracts. I understand that it's not allowed. I
Right, it's
understand.
contrary to the instructions, right?
Yes. That being said, the defendant in this case did testify to some very specific legal terms, especially regarding EMED, which I do want to be able to comment on.
Just to be clear, I mean, our position is EMED should not be given, and we're telling the jury it did not apply. And when he said that, yeah, I was in a severe emotional state, he was talking about after the fact, not when he did what he did. I asked him, how did you feel immediately after this? He said, I was in a severe emotional state. So that, like, if he's suggesting that he said that to try and get convicted of EMED, that's ridiculous. Because number one, we're saying EMED should not be given. We're telling the jury that it should be disregarded. And number three, the comments he made about being in that state was after the fact. Obviously, for EMED to apply, you have to be in that state during the incident. So,
And that's the only tailoring argument that you're considering, Mr. Garner?
Like you say, make it sound like I should be considering more, but that's the only one on my mind at the moment.
I'm not suggesting you should be considering more, but because my general inclination is to keep it out at this point in time. And so I wanted to know if you had more, because I will go back in and I will reread Walsh and anything else connected with tailoring to see if it changes my initial inclination, but that's what it is right now.
Understood. Thank you for sharing.
And just to get into that a little further, number one, nothing in the evidence had to do with EMED or the standard for it, right? So it's not like he would have heard that throughout the trial, okay? Hypothetically speaking, if there ever was something to do with that, arguably someone in that position would have learned about that through his attorney. So now you're getting into attorney-client privilege communications.
Well, that's not true, because we were all here when we settled jury instructions and we had a long discussion of State versus Perez and State versus Moore. But again, my inclination is to not allow the Taylor argument. If we need to take it up, but I'm happy to make a record.
Well, I respectfully, when you say that's not true, I'm not going to get into my communications with him, obviously. But obviously, any attorney who does this work would have, had discussions about it before settling jury instructions. So I understand when you say that's not true, what you're saying is he could have also learned it from other places.
But here in open court, when we settled jury instructions, I'm pretty sure Dr. König was here.
I understand that. I'm just suggesting when you start getting into what a person may or may not know legally, you're getting into communications with their attorney, regardless of if the same subject matter was discussed later.
Mr. Otake, anything you want to take up before we adjourn?
I don't believe so. I guess is the idea that closing would be an hour?
Good.
We can talk, yes, we'll talk about scheduling again up here at the bench once we adjourn.
Oh, okay. The time limits.
Just an hour
Okay,
for
so
argument
there's nothing
each
further.
side.
We'll adjourn.
That is good to see.
Council, come up.
All right, so let's get Lincoln and John again. John, can you hear us?
Yeah, can you hear me?
Yep, loud and clear. So tell us what the jury was doing during this last half since we had John at lunch break.
You know, there's not a lot of expression on their faces at all. They're, I'll call them stone-faced. Just no expression. There's not a lot of smiling. In fact, I've only seen one smile today coming from a juror because I could sense that they're picking up on the ridiculousness of what Dr. König was saying. But that was it. So I would say they're locked in and they're fully aware of everything that we're seeing. And I don't think they're going to buy any of it. Just my gut intuition on it, Carl.
Yeah, I think that since not the lunch break, but the short break they had after lunch break, it seemed like all of a sudden he was admitting to having more recall on events. So I thought that was very, very much a sign that defense said, hey, you're saying too many I don't recalls.
Mhm.
And so, like I have said this afternoon several times, he knows every inch of that file, every word of that file that the prosecution has, they've turned over to defense. And he knows all the information they're trying to use against him and they're going to impeach him on. So for him to say, I don't recall this and I don't remember, and then he sort of like says, well, I must have, but I just don't recall. That's just not credible at all. So I just think that his selective recall and amnesia, it's just, he just thinks himself. And so also there's no emotion. He doesn't seem like there's any kind of concern or regard for the bloodied head and face his wife has. He doesn't talk. He never talked either yesterday or today about any kind of loving relationship he had with his wife, and then he's trying to salvage this. And so it talks very cold about the whole relationship, I think. So and given the fact you say there's 10 females on the jury, and we don't know how many will be selected as primary, but odds are this is going to be a majority female jury. So they're going to notice that lack of emotion and lack of concern for his wife's well-being. And to think that this guy uses a rock because somebody's squeezing him in the crotch is just absolutely ridiculous.
Yeah, I agree. My gut is they're not buying a single thing he's saying.
All right.
There's nobody, and also little things like when he's back at the defense table just a few minutes ago, I look at the jury to see, is there anybody looking at him trying to, give him some sympathy or checking in with them? And there's no looking at him at all when he came back to the defense table and sat down, for what it's worth.
What we don't see, and Leslie and I were talking about this at lunch break, is that, we don't see him like having any like outrage that he was set up this way.
None.
You notice that? He's not
that's a good point.
acting like, my gosh, I went here, and then all of a sudden she's going to turn on me, and she starts, tackling me and grabbing me. And,
nothing.
And then she, you can talk very exact details, and he has no emotion. It's just all flatlined, and it just sounds like he's made stuff up. And then his lawyer is filling in details like, well, what about how close to your face was it? And those kind of details. The attorney's like having to fill in the stuff because he's forgetting to go into enough detail. So are you picking up on that as well, John?
Yes, and I don't know if you guys pick up on it, but the attorney is always in a bad mood. So he comes back. You guys didn't see this, but after the last objection of his was overruled, he kept standing and had his arms out like, you got to be kidding me. You just
wow.
overruled. Yeah, it was he stood for about an extra 10, 15 seconds after the judge said overruled and the testimony moved on. He went sit down. He still stood up almost like to plead his case. Like, are you serious, judge? So throughout the case, I've seen him just kind of be in a pouty mood.
Yeah, that's a
You know what I
bad
mean?
thing to have in front of a jury
Pouting.
and a judge. Even if you're just doing a bench trial, having that kind of attitude with the judge, like you disrespect the court that way. That's not a good thing to have, especially in front of a jury. And then tell us also what you're seeing from your perspective about how he just walks up there and calls his own sidebar without asking permission from the judge.
I've seen him do that twice. As he is saying objection, he actually starts walking towards the judge, assuming that the judge is gonna say yes, and the judge did say yes, because he always does, right? I guess judges normally do that.
Yeah,
But
normally.
it's just almost very bossy, like he's in charge of the courtroom.
What about
See him?
what about the judge's outburst right at the very end there? What did you see on that?
Oh, he was ticked. He kept looking at Otake for about 3 minutes after they went back there. And of course, we can't hear what they're saying, but they were going back and forth. And you could tell the judge was saying some stern words towards him. Just couldn't make it out what he was saying.
Yeah.
But you could tell he was really ticked off at Otake at that point.
What would you say to me the defense attorney seems desperate, nervous, like he's got a losing case and is going to lose. He doesn't have any confidence when he's arguing. He sounds too whiny and snivelly on his presentations and objections. Do you pick up on that?
The take I have, Carl, is that he's doing his job as best he can, but he doesn't have much to work with. And I think the jury probably thinks the same thing on that. That's what it comes across in the courtroom. By the way, the courtroom is very small. It's about half the size of the Adelson courtroom in Tallahassee. So you're very close to everybody. And if you saw how close the jury was to the defendant speaking today, it's pretty. I've never seen a courtroom this small, Carl. So it's very intimate. But when the jurors walk by you, because they have to walk by, it's both coming in and leaving, not a single person looks up at anybody. They just come in like they have a job to do, sit down. I would say a third of the people are note takers. The 2/3 aren't note takers. But I don't think they're being, to use your word, I don't think they're going to be bamboozled by anything Otake's coming on with.
Yeah, I just don't see it happening. There's some people that say that he's credible and Ariel's not, but I just don't see it happening at all that way. I mean, as I've mentioned 1 year in the courtroom, that we have naysayers for every single case, where it's Corey Richards, Charlie Adelson, Murdo, plenty. There's a number of folks that always thought Karen Reed was guilty. So so there's always going to be folks they don't see it for what it is.
Totally agree. There are always going to be trolls to join the chat.
Yeah, we haven't heard whether the defense rests or not, but I'd be surprised if they call anybody else. So we have a 40.
I didn't hear there.
We have a 4-day weekend coming up here. Good Friday starts tomorrow, and I assume the court holiday's Monday, so Tuesday's when they start up.
Yep. 9 a.m. 9 a.m. in the morning, I think he said. So, yeah, the jury comes across as very professional, very tuned in, very interested. There's not a single person that seems like they're falling asleep or is disinterested. So I think they get it. I'll bet you they'll look forward to getting back there and actually finally being unmuzzled and being able to talk about this case that they've been, having to be tight-lipped about for so long.
I thought it's interesting that this is such a stand-up guy. He was looking forward to being able to pay child support.
Yeah, right. Unbelievable.
I've never seen that before.
Yeah.
And with this kind of money, he'd be paying like the statutory maximum.
Right.
So probably like 2,000 per child or something there in Hawaii.
Carl, what'd you think about the impact of that, having that bloodied face of hers up large on the screen? That was very large on the screen. And then his face next to it, much smaller, not bloodied up. And it was up there for a while. I thought that was a good impact to have on the jury, kind of just a summary of what happened on that day.
Yeah, I just wish I thought that was a really good job. I complimented the prosecutor, but then I thought it was very good if they would have taken that and reintroduced it when they talked about this is what you saw on the edge of that cliff, and you left her like that and ran away like a coward.
Yeah, that's a good point. Yeah, that's a very good point. Yeah.
I mean, you'd leave her in that condition and take her phone. Now, granted,
Right.
some women were coming up to rescue him, so you rely on a couple women to save her. You know, if she's trying to falsely accuse you something, still, it's like, honey, knock it off. You know,
Right.
you're not gonna get away with this. And so he's acting like he's totally guilty of a fake attempt to kill her. He's not acting like he was falsely accused in any of his behavior from that point on.
Yeah, I agree. Yeah, it's
So-
really, really bizarre.
Well, it's about 8:30 here Central Time, so we'll go ahead and sign off here, folks. Thanks for your support there, John.
You bet.
Give me-
I won't be
give
here
me-
next week, so we'll just watch it online together.
All right. Well, thanks for your in the courtroom
bet.
reporting. And folks, I don't know what I'll be planning for this next week, but I may cover it full day coverage. Not sure yet, but I'll try to give an announcement at least by Monday sometime when I plan to cover on. So instead of doing a full day coverage like this, I may just do an evening recap. But more to follow on this. But thanks for supporting justice, and have a great Easter weekend. Take care.
Bye.
All right, John, you there?